and move an application. The urgency is that when the tenancy has already expired, 3.5 lakh rupees rent, there is no question of issue of jurisdiction. They are in the process of creating a third party, inducting somebody else. So, my lord, I would be praying for, my lord, leave to present the plaint and move the application. My lord, otherwise, the procedure is normally, my lord, plaint is filed, then thereafter the application. So, if it could be done, my lord,
So what you want now?
to present, leave to present the plaint and, my lord, move an application. My lord, if it could be done tomorrow, my lord, we shall file it. But if it could be tomorrow,
Tenancy, what is the urgency?
they are creating third party interest. My lord, we have given them it is expired by a flux of time, so they have no right. It's a prime property, my lord, it's a restaurant, and they're inducting somebody. It's a franchisee which they are wanting to induct.
Oh, leave granted to file today and to place tomorrow for presentation.
Grateful.
No.
I'm grateful.
Sir, may I be permitted for a leave to draw up an order?
Just a minute. As per the urgency pleaded, leave is granted to file in course of the day and to place before this court tomorrow along with the
And a leave to draw up an order dated 31st July 2025, my lord.
31st.
July 2025.
I have my lord's leave and under compelling circumstances mentioning this election petition before your lordship. My lord, by order dated 13th August, my lord has directed the petitioner to take steps to publish a notification in terms of section 116 read with rule 41 of our honorable court rules, my lord. My lord, the section 116 specifically directs the high court, my lord. We have already given a notice to the register original side. They have already prepared the draft notification. But as my lord has directed the petitioner to publish the notification, they are not being able to take steps to publish the notification. I am humbly praying the matter can be kept tomorrow as to be mentioned. They have already sent a office report to your my lord's officers, my lord. Probably that's what have been told by the registrar's office, my lord. If the matter can be kept tomorrow as to be mentioned, my lord, this
report आया है क्या?
EP number 3.
Election petition.
That was I was
tomorrow.
Tomorrow.
हाँ? Report आया कल रख दो.
But tomorrow has
तो
to
non
be
commercial है ना?
non commercial, my lord. It is actually fixed to be day after tomorrow, my lord.
Day after tomorrow is
Yes, my lord.
Let it come day after tomorrow.
My lord, as my lord has only directed that within 3 weeks I have to
Okay, I
publish.
will see to that.
My
The
lord,
report
my
is there, no problem.
My lord, I should
With
be
your-
grateful.
May I have your lordships kindly to mention item number 7 of your today's lordship list, my lord. There is a suit, my lord, but it's fixed at 2 p.m. But I have an instruction that the matter would be withdrawn, my lord. That's why I'm indicating.
Come at 2 and withdraw.
With your lordship's leave, may I be permitted to mention a matter, lordship? Lordship, in this matter, the interim order expired on 29th August, lordship. We went and mentioned before the Honorable Justice Arindam Mukherjee, but unfortunately, he was not being able to publish a supplementary list that day. So he asked us to mention before your lordship on Monday.
29th. Which was the
29th.
other side?
I appear for the other side. Yes, I can't stand in the way.
Yes.
Only prayer is, well, this Friday is, we've heard rumors that may be declared as a holiday. But next Friday, if your lordship keeps the matter fairly at the top, because this has been going on for some time, and Mr. Ghosh is supposed to make his submissions in reply. It may not take much time. And well, the prejudice that we are facing is that they are showing the order of injunction before the suit now, which has been filed before the Alipur court.
No, lordship, that is going on.
Very well,
That is
that's
going on.
my
It's
instruction.
Contempt.
Contempt, lordship has passed an interim order restraining the contemners from giving effect to the deed of conveyance. Lordship would remember the
Yes.
conveyance was executed as per their allegation after the order of
After the
injunction.
order was passed.
Their allegation is that, but
So
we had made our submission.
only you have to give the reply to that.
But we have completed.
We have to give reply.
But they have to. They are the petitioners. They have
Yes,
to give reply.
Mr. Ghosh has to
Yes,
give the
yes.
reply. The matter is mentioned by the learned counsel for the petitioner and submits that the interim order passed earlier was up till 29th of August 2025, and this court was not available on 29th of August 2025. Accordingly, the petitioner has mentioned the matter before the honorable court. Honorable court, who has taken the urgent matter, but inadvertently supplementary list was not published and interim order has not been extended. Now the learned counsel for the petitioner prays for extension of the interim order. Considering the circumstances mentioned above, the interim order is extended. When the matter is fixed, 29th.
Yes.
29th Lordship.
कोई time है नहीं है. Let the matter appear on hmm?
One is
Today is the first. The matter appear on
It's the good keeper.
18th September.
18th September.
18th September under the heading Content Matters at the top. Interim order extended till 18th September 2024 until further order, whichever is.
Your Lordship, the matter is already.
My lord, may I have my lord kind leave to mention
19th.
my lord, two matters, my lord. First, my lord, item 146 of your lordship's list. The Rahi matter, my lord, when my lord, I was just on the verge of my completion. My lord, can you fix a date and time, my lord?
Today nahi, today's
146.
146.
No, it's not fixed, my lord. That kept it, my lord, would have taken a chance that my lord, if my lord can take up, my lord, without fixing a date and time, but my lord, kindly fix it a date and time, my lord. My other side is here. Any date and time, my lord, so that I'll complete then, my lord.
Date and time is the difficulty. After vacation. What number? At दो डेट दे दो. What बोला?
না 13 নম্বর কটা বলতে Millard kindly keeps it a week Millard either Millard 13th November kindly it's possible or Millard 17th subject
17th and 19th at 2 p.m.
at 2 p.m. complete করে দাও and Millard with regard to Millard the
Just
not
a minute. Yeah. Yes, in this matter you want to make any further submission?
no 17th and 18th.
Though the matter is listed as item number 146 in the today's list under the heading argument, but the London Council for Council for the parties press for fixing a specific date and time so that the matter can be concluded and the argument can be concluded. In view of the submission made by the council for the parties, let the matter appear on
Millard can it be on 17th and 19th subject to
17th and 19th November 2025 and
first half করে দিন না first half
12:30. 17 at 2 p.m. and 19 at 12:30 p.m. for argument.
শুনে না
Yes.
Your Lordship,
another matter এক মিনিট
Yes.
Millard another that's not about that matter Millard it was fixed at 10:30 this
It
28th
will come Wednesday. It will
Millard
come on
kindly keeps it at to be mentioned this Wednesday
Yes,
kindly don't
Wednesday it will come.
yes
As to
let
be
it be as to be
mentioned, it will
mentioned
come.
yes আমি নম্বরটা
I already informed.
yes আছে তো very হ্যাঁ দা
Your Lordship, the matter is already running at item number 143. And for the petitioner, you would like to withdraw the matter, Your Lordship. So the matter may be kept as to be mentioned tomorrow.
43 CS.807.
Yes, yes.
इसको कल का रख दो for withdrawal within bracket withdrawal. Who is
Much
for the other
obliged.
side?
Other
Have you
side, Your
informed?
Lordship, we have already served.
Inform other.
Yes, yes.
Again
Sure.
inform. Come tomorrow.
Much obliged.
And with written instruction for withdrawal.
Much obliged.
Without written instruction, I will not allow.
Much obliged.
My lord, may I be permitted to mention a matter, my lord? Company petition, your lordship. My lord, I am seeking, my lord, a liberty to file the application, my lord, with the department, my lord.
File the application in the file it.
My lord, the department is not willing to file the application since, my lord, the main company petition has been transferred by your lordship's order, previous lord, my lord, order of 5th June 2023. Now, my lord, since the records
Where
are lying
transfer? Tribunal.
to NCLT, your lord.
So go to the.
My lord, the records are here, my lord, only a humble direction to the, my lord, my claims are against the official liquidator. I am an agent of.
The order is there is an order for transfer. How the court can pass an order in the interlocutory application if the record is transferred?
And if my lord kindly takes it up and my lord disposes
You
it.
do one thing. Come tomorrow, my Wednesday,
My
when
lord.
the company matter will be taken.
My lord.
You mention, we'll see to that.
I'll be so grateful, your lordship.
My lord, may I have your lordships kindly, my lord, 3 originating summons suits that were appearing on Friday, my lord. Even last Friday, my lord, it was appearing. My lord, I apprehend because of coming Friday also being a holiday that we are requiring, my lord, very urgent, my lord, interim reliefs. Can it appear on Thursday, my lord?
Thursday, what time? My total day.
Anytime, 3:30, 4 o'clock. Before
What is the urgency?
before the vacations. My lord, that matter where your lordship has already passed an order, similar matter, my lord, trust they are taking away the entire money, that recalling of that similar matters.
Come. Thursday. Hey. Number लेके कर दो.
CSOS number 678. আমি দিয়ে দেবো 678 আমি দিয়ে দেবো।
Present.
শুক্রবারে ছিল।
It is present here? No.
শুক্রবারে ছিল।
Where is that?
45 তো।
Okay, come back to otherwise if it was
CSOS শুক্রবার ছিল।
Okay, you give that. Both the side. इसको publish कर दो production करके. Yes, call the list.
May it please,
Malada.
the other side to file the written notes of arguments.
Yes.
But may I file my written note?
May I request it can be emailed or served on my, or Mr. Rajat is online today, so I probably could just email them or we'll collect a copy from them.
I have not received that copy, my lord. So let us do an exchange copy with each other, my lord.
No,
I'll
both
serve
the-
them. I'll serve them if they serve me, my lord.
Yeah, we'll serve you.
Yes.
We'll serve you, not a problem. We'll serve you, not a problem at all.
Simultaneous, my lord.
Very well.
I'll
Well,
serve Mr. Sengupta.
You already filed, Mr.
Yes.
Ingorani. You already filed.
we filed on the last date itself. It's in the order sheet. We've already filed it on the, it was in the order sheet.
Yes.
And my subsidiaries application GA2 is listed. The council is also on virtually
I have
here.
this for the applicant in GA number 2. This is an application for dismissal of the execution proceedings in on accordance with the arbitral award being a product of fraud and collusion. And this is listed for the first time for issuance of notice today.
Okay, let me decide this, then we'll see to
Oh,
that.
yeah, applicant and intervener. I'm being led by Mr. Postman.
Counsel for the petitioner has filed written notes of argument. Let the same be kept with the record. CAV.
Grateful.
Court would be indicating a date for the other GA.
That should come in its usual course if they have filed it.
Let it will come. It or you mention, I will see to that.
Well, it's a joint order can be passed since the contentions raised are similar in both the applications.
Right. But hearing is
How then hearing is to be done? This
Yes,
takes
actually,
taken about 6 months.
Yes.
If I may just submit,
The
this is,
issue of maintainability has been raised. So once
this is,
if the
this is not-
maintainability succeeds,
Yes.
then the issue will.
Yes,
if
yes.
I may just make a submission, this is the whole point Mr. Bose was saying that you're a third party, the JD is not filing anything. Now, these are newly appointed
So
directors.
this is not the now. This is not the
Mr.
time to
Ingorani,
cure the
that
defect.
has been
Yes.
filed. Okay.
So
You do
these
one- record
applications,
an
your
order.
lordship can understand that these are to cure the defects of
as
the
regard the
application.
GA2, as regard GA2 mention and GA2 of GA Comp 2 of 2025.
Not curved.
Let the matter appear on
We wrote to them, but they're still not.
12th of September 2025.
But only one thing, my lord.
Would it be 13th September? is
They not
convenient?
served. I write to them, please serve. Even then not served.
In the meantime, the applicant in GA number GA Com 2 of 2025 is directed to serve the copy to the learned advocate appearing for the parties.
Could it be 13th September? So would it be possible to have 13th September?
13th is a Saturday.
13 is you're most welcome.
Then on that case, 15th September if it's
15,
convenient.
15.
Deeply obliged. Deeply obliged.
Obliged, ma'am.
Or
Grateful, that's fine.
GA1. No.
GA2.
CAB.
CAB was
GA1.
well, GA,
GA1.
GA1. That was GA1.
GA1 of 2020. Old GA 39 of 2020.
My lord.
Yes.
Deeply obliged.
Obliged.
और उससे पहले item number 3.
Yes, my lord, I appear
This,
for the
this
plaintiff.
is fixed on
3rd, yes, September.
for hearing.
For examination in chief of the.
Yeah.
I am appearing, my lord, for the defendant.
Just Mr. Call that matter. 4.
Number 4.
Item number 4, Mr. Dutt. this interim order was passed up till 3rd. So I want that on the 3rd, the total interim application is to be, identity is to be disposed of. If all the parties are agreed, then other fixed matter I will postpone and this matter will be taken.
Yes, my lord. In fact, my lord, we had, my lord, wanted to give notice, my lord, for my lord, vacating of the order which your lordship has-
That's why I appreciate. That's why I fixed it to be mentioned so that on 3rd itself the
Yes,
matter
my
can
lord,
be
because
taken.
I want to just indicate one thing. My lord, the mentioning notice did not mention why it was being, my lord, mentioned. My lord, neither Mr. Banerjee nor I, my lord, could, my lord, make it. And my lord, unfortunately, it seems, my lord, an impression has been given to your lordship, my lord, that the entire premises was in the occupation, my lord, of, my lord, the plaintiff, which is not the case, my lord. The documents on record will also show to the contrary.
Okay, I will on that day.
Hey.
If all the parties ready, the total
Yes,
matter
yes, my lord, my lord,
I will hear the matter so
yes,
that the identity application will. So
and my lord,
so
I
will
shall,
fix that.
Shall file a supplementary affidavit because that day when I mentioned the
Whatever
matter,
you want, you file this.
I'll give
Give
a
the
copy
copy
to my
to them. What you?
because my lord, one factor which will become relevant, my lord, is the conduct of a party, my lord, even during the course of litigation. So I shall, my lord, make my submissions, my lord, on, my lord, how, my lord, the order was, my lord.
Okay, okay, no problem, no
I
problem.
just want to indicate.
Record an order. Item number 4. Let the matter appear on 3rd September 2025 at the top under the heading New Motion for hearing of interim application.
well, at these two supplementary, I've got them ready on that very
No,
night.
I am not taking to the mention. You keep it. It's of the.
I'll serve
They
it.
can serve us in case we need to deal with it, my lord, we'll file.
I'll serving it here.
Serve it in course of the day. Yes, call the 3. Item number 2. Item number 2.
Should I appear for the plaintiff?
Yes. Item number 2 is appearing.
Yes, my lord.
Hearing matter.
Yes, my lord.
So I want to defer this hearing because there is an urgency
I'll leave
matter
it
I
to your
have to
lordship.
take
I'll
up.
leave it to your
I will
Any
defer this
day
and
which is available,
after
lordship may
vacation I
fix the
will
date.
fix. I will
Lordship
fix.
kindly fixes the
No,
date.
kindly fixes the date after the vacation.
Then
so
fix
that
the
it's-
date and time I am
Yes,
fixed.
absolutely.
Lordship.
Though the matter is fixed on
3rd of September at
3rd
11:30.
September at 11:30 a.m. But due to some but it is not possible for this court to take the matter on 3rd September 11:30 a.m. Accordingly, the hearing of the case is adjourned. Let the matter appear on कब ना 3rd नंबर कोई नहीं रखना है. 3rd नंबर पूरा डे वो चलेगा. हाँ वो नवंबर 12 नहीं होगे 2 PM 2 बजे 3 बजे क्या है 17th November at 3 PM
17th at 3. I'm grateful, Lordship.
7 no, 3.
11:30 12:30 मत रखो इमरजेंसी होने से लेके आएगा उसको. Yes, call the 3rd. Call the 3.
Yes, my lord. This is 12:30 fixed on.
This is also
Yes,
But I am appearing for the defendant.
it's emergency. That's why I put because your witness will come then it
Yes,
will
my
be
lord,
difficult
yes.
for that.
He'll come from outside, so my lord, if it could be kept after the vacation, my lord.
Witness has not yet come, na?
No, my lord. He was
Though the
about
matter
to
is
board,
fixed-
I'm told.
Though the matter is fixed on 3rd of September 2025 at 12:30 noon,
I don't know why.
12:30 PM for further examination of the plaintiff witness 1, but this court will not be in a position to take the matter on the date fixed. Accordingly, hearing examination of the witness on 3rd September 2025 at 12:30 PM is adjourned. Let the matter appear on 18th November at 2 PM.
Very well, my lord. Great.
Grateful.
Yes, call me.
Lordship, I'm for the plaintiff.
Yes.
It's a commercial dispute, Your Lordship, which is arising out of supply of services to the defendant. The petitioner, the plaintiff supplied coal from CCL to its to the required place. Your Lordship. So for this work, the defendant issued several work orders for handling and transportation of the coal from the colliery point of CCL to defendant's power plants, which was in Aditpur, through road and through railway come road mode, both, Your Lordship. So between September 2015 to October 2017, various work orders were issued, and defendant, in lieu of the services rendered, released part payment against the bill raised by the plaintiff herein. But a huge amount of it, the huge amount of the bills remained unpaid because it was to be paid after the settlement of account between both the parties, Your Lordship. So the entire amount which was raised in as per the bills were never paid. There had to be a settlement of accounts. But unfortunately, in between, in September 2019, both the directors of the defendant company, they were arrested in relation to a NIA matter, and after which the plaintiff was also arrested, Your Lordship. So the settlement of account could not be done. Now we were released in March 2025, after which the plaintiff tried to get in touch with the defendant. In between, Your Lordship, people from the defendant's family or known people from the company, they tried to approach the defendant's company, but they were told that because the MD is the signatory authority is also in jail, so once they are released, the payments will be done, Your Lordship. So once the plaintiff was released, because he's the signatory authority, so when we tried to get in touch with the defendant, then they refused to take a call. And that is when the cause of action arose, Your Lordship, in March 18th, 17th, 18th of March 2025, Your Lordship. So after which we went for the mediation, but they did not appear in it. That has also been filed along with the case, Your Lordship. So we are before Your Lordship because almost pending amount to the tune of 9 crore, and if you add interest to it, it almost amounts to 21 crore, Your Lordship, is pending unpaid.
So when the last supply was made?
In October 2017, Your Lordship, because after that, that was the last work order, Your Lordship.
So one last work order. So how you explain the limitation period?
Your Lordship, because the settlement of account was not done. It is not done till date, Your Lordship. And in between, when the NIA, during the process of NIA hearing, Your Lordship, in the year 2023, Your Lordship, it's annexure EB, Your Lordship, that is also on record, wherein for the first time it was brought to the notice of the plaintiff. Your Lordship, if I may take you to page number 38, Your Lordship, annexure B.
Yes.
So if Your Lordship, this is the explanation memorandum. On 2nd August 2023, Your Lordship, for the first time, we were given a document by NIA with regard to settlement of account, which was provided by the defendant company during the course of investigation to NIA, Your Lordship, in which they have agreed that this amount is pending. They have acknowledged, Your Lordship. It was brought to our notice. It was produced before us on 2nd of August 2023, Your Lordship.
Okay. So what do you pray for now?
Your Lordship, for declaration of money decree, Your Lordship, for payment of the amount due, Your Lordship.
I order to rule 2. It is the simple recovery of money with regard to the supply of goods. Why the order to rule 2?
Your Lordship, they are denying, Your Lordship. They're not.
That is, see, this is the work. You are claiming your amount with regard to the work,
services, Your Lordship, services rendered because we transported.
What are the materials you supplied that they have not made the payment? That is a simplicity you have made out the case. So how the order to rule 2? Maximum you will get the interest. That will cover them. That cannot be an order to rule 2. Compensation will not come further damage. I don't think. Why the order to rule 2? Which paragraph you have narrated? Order to rule 2?
Your Lordship, we have Your Lordship, paragraph number 16, if we see, Your Lordship, wherein we have said that the plaintiff number 2 was released from, they did not make the payment because of.
That's correct. See, madam, your simple case is recovery of money against the goods supplied to the defendant. That is
Lordship,
correct.
Lordship.
So your case is totally based upon the work order.
Lordship.
And supply invoices raised against the supply order.
Not entirely based on invoices, your lordship, because from the very beginning, since the inception, the entire payment was never made. It had to be done in accordance with settlement of
Okay.
accounts,
So
your lordship.
why order to rule 2? Why order to rule 2? And all the parties are within the jurisdiction.
Yes, your lordship, all the parties are within the jurisdiction, your lordship.
Cause of action also within jurisdiction.
Yes, your lordship, because the defendant's place of business is in Kolkata, and all the work orders also specify Kolkata as the jurisdiction for all disputes.
But madam, kindly come to your cost title. Frame because so and so, it was so and so. This is Jharkhand. The Jharkhand.
Your lordship, the
Residence of the Jharkhand, your address is of Jharkhand. How? So where is the order? Clause
the
12.
defendant's order is, your lordship, Kolkata.
Defendants is okay, Pura Bazar and all this thing, no problem. But kindly come to the defend number 3 also. Again the Jharkhand.
Your lordship, but if we see, your lordship, the work order, the jurisdiction has clearly been stated to be Kolkata, your lordship, page number 25A. 25, all the work orders that we have said, page number 25, the first work order itself, your lordship, annexure A, clause 7, jurisdiction. This work order is subject to Kolkata jurisdiction for all disputes, your lordship.
That's correct. I am not on that. Your office is at Jharkhand.
Yes, your lordship. Yes, your lordship.
Your office is Jharkhand. Your address is of Jharkhand.
Yes, your lordship.
Number 3 is also of the Jharkhand.
Your lordship. But 1 and 2, your lordship, it's Kolkata. Their head office is Kolkata, your lordship.
Okay, you have to face your consequence. Yes.
Lordship, I'm being led by.
You consider this with regard to the jurisdiction. You mentioned the cost in the cost title, plaintiff and the defendant 3 of the Jharkhand. You consider clause 12, whether it is leave is required or not. Otherwise, in future you will be in problem.
Lordship.
What you want now?
Lordship, the jurisdiction will fall within your lordship's court only, your lordship. The jurisdiction would be of Kolkata High Court.
Where from you issued the work order?
Aditpur, your lordship.
Huh?
Jharkhand.
Then
Lordship, page 24, annexure A, the work order, right at the below, right at the bottom of the work order, it is given.
Kolkata.
Office, Netaji Subhash Road, Kolkata 1. It was
Kolkata.
Netaji Subhash Road office. Back then, Adhunik Power had an office in.
But then you come. That's why you come to the cost title. Come to the cost title of plaintiff.
Close to it. Netaji Subhash Road.
Then come to the page, defend number 3 address. And kindly come to the paragraph 1, 2, 3, where is within jurisdiction, where is your pleading? In the cost title also there is no pleading whether within jurisdiction or outside of jurisdiction. It is not drafted in Calcutta.
It was not drafted.
That's why. Where is the pleading?
Your lordship, pleading is on paragraph number 23, page number 13, your lordship.
No. With regard to the address within the jurisdiction means cost title, and with regard to the description, you have to state whether it is the defendant is with or the plaintiff is within the jurisdiction or out of the jurisdiction. Where is that? 25 is stated that the cause of action. Not 25. Where is the 25? 24 is the prayer court.
23, your lordship. Page
Complaint.
number 13.
That is the 12A.
Lordship. So after that, it said that it is said that.
Madam, please, you consult the advocate from Calcutta. Please go through. There is a format filing of the suit in the plaint, in the cause title, in the paragraph. You have to mention whether it is within jurisdiction or whether it is outside jurisdiction. Otherwise, it is very difficult to get the suit admitted here.
Lordship may kindly grant us the liberty to amend the plaint and file it, your lordship.
What amendment? First you take the instruction, what amendment is, then I will
Lordship.
grant. As per the prayer made by the counsel for the plaintiff, the case adjourned, let the matter appear day after tomorrow under the same.
Lordship. Obliged, your lordship.
Yes, call the matter.
Will appear for the respondent in some of the applications, the plaintiff in the suit. This is that matter of that cafe in Park Street.
Yes.
Short Passover. He is in court number 41.
Court number 41.
Or we can come back at 2 o'clock. This 2 o'clock matter will be adjourned. It's my matter only. We will withdraw the matter. I know.
Come at 2?
2. Obliged.
At 2.
I think the matter was mentioned in the morning, the 2 o'clock matter.
I don't know. If it is adjourned,
we'll withdraw. I know I have given instruction to withdraw it. We'll come back at 2 in this matter. Obliged.
11, I am for the petitioner, my lord. 2 p.m. Yeah. Item 11.
2 p.m. we'll come back. One small reply, 5 minutes will take. No, other applications are there. So we can hear all the applications. I've got a matter fiction online. One small reply, 2 factors.
Okay, I will solve.
Yes, completed. I have completed. ठीक है, देखो नहीं, ठीक है. दम, ये दम. जी कौन-कौन की चीज़ बोलो. This going to display.
My lord, this is the application where I'm seeking dismissal of the plaint because according to me there is no case made out for taking exemption 12A.
GS6.
GS6. Lordship, my friend, what I gathered from his submission, that he was only on the score that since there was no interim order in my suit in the appeal, when there was no, that in that period, interim period, when there was no interim order, so it becomes so urgent for him to apply for this case. That was what I gathered from his submission, Lordship. Lordship, I would just like to I was also wondering that why there was a gap of the interim order. So I took some research work on that. Lordship, only thing Lordship will kindly see. Lordship, when the interim order was passed by the Honorable Division Bench, it was presided by Honorable Justice Chittaranjan Das and Honorable Justice Partho Sharuti Sen. Now, from 6th May 2024 to 15th May 2024, this bench was not sitting. I'll just show you some connection with that. So let's go to copy them.
Not sitting.
Not sitting, Lordship. Copy the list. Nothing here. Now, Lordship will find that on 13th May 2024, my page 267 of my application.
GS7 though?
267, my application, Lordship, GS6.
Yes. This was on 13th May.
13th May. So if you see, this order was passed by Honorable Chief Shomen Sen and Honorable Chief Uday Kumar.
Correct.
Because this was not the original bench, so matter was listed there. We approached, we prayed for interim order, that was extended. And that was extended for 3 weeks, am I right?
Continue for 2 weeks
2 weeks.
from date.
So if you see the date, 13 May, 2 weeks if you add 14 days, it comes to 27 May, there was the summer vacation. The courts were closed. Now, our High Court reopened on 10 June. On 10 June, the bench was where was supposed to have my interim order extended or to apply for the extension. That was presided by led by Honorable Justice Madhuresh Prasad and Honorable Justice Supratim Bhattacharya. तो वो interim order service का कब तो देर एक within time file किया था मेरे application open कर दिया था application तो file किया था within time एक मिनट दे within time file हुआ तो serve किया copy ये तो हमको ये भी तो serve कर
Yes.
No, Lordship, my interim order was expiring on 27th May. Within time, we affirmed the application. It was filed also. Now the court reopened from 10 June. Now, my battle from 10 June to 21st June, the bench was again not there. Now, in the meantime, Lordship, we served the copy of the extension application to my friend. This was served on 13 June. This was this service of the copy of my extension. So he was quite aware.
When you affirm?
It was affirmed on 24th May. I'm showing you the copy of the application. That was within time. I'll just show you, Lordship. That is why subsequently my interim order was extended. वो तो application था can number. उनका जाओ था थोड़ी. Action के रखते बोलो चलो आप भीतर ढुके दीजिए.
So this the 10 June 2024 to 21st June 2024, the court was not
there.
Not there.
But it was served upon them. It was filed within time.
So whether the determination was given to any court?
No, Lordship. Lordship.
Court?
No. Lordship. The bench was not there. Now we have served the copy, so we were in the notion that he is aware of that extensive interim order. His copy has been served, so he was quite aware of.
When you affirm the extension
Lordship,
application.
24th, I'll just show you the copy. We have got the copy. My jurist searching for that. I've seen that. It was within time. It was done. Lordship, 24th May.
Served on
13 June, because there was a vacation. Court opened on 10 June. We served on 13 June.
Okay.
Now, Lordship, it's fine. That is why subsequently on 8 July, when the bench was there, we moved this application. It was running in the list. So Lordship was pleased to extend my interim order.
8 July.
8 July.
Order next.
What? Page 270. Now, what my friend has done, he prepared this suit and he has filed this suit. He's got this affidavit done. On 13 June, he received the copy extension. He was aware that the court was closed. So on 13 June, he was just waiting. He was waiting for that gap. If there is any gap, if it's not extended for some reason. But Lordship, I've shown you that benches were not sitting there. I was doing my all attempt to, apply for my extension within time, Lordship. I have not delayed. There was no intentional latches from my part. Now, if this is his contention, that just because there was no interim order, that is what he insisted on the last day of hearing. There was no interim order, so it becomes so urgent, I have to apply for this thing, Lordship. Lordship, whether that amounts to any urgency or not, I was just asking the question to myself, Lordship. Whether that is going to fulfill the criteria of section 12, this is number one, Lordship. Number two is that he said in his affidavit that since in March 2024, I came to know about the interim order. And in his paragraph, he says from June 2023, the dispute started. So from June 2023 to March 2024, there's no explanation. What steps he have taken? My suit was filed in December 2023 in City Civil Court. Interim order refused. He was not aware. Accepted lordship. I say that he was not aware of that. I applied for my appeal in the High Court. He was not aware. I got the interim order on 27th February. I served him the copy. He came to know in the month of March. Now, if you see his pleadings, he has not given any plausible explanation that what steps he took from June 2023, where he said in a paragraph that the dispute started, to resolve it by taking a premeditation, whatever is there in the provision.
So now what has happened to the appeal?
Appeal has been disposed of, referred back to City Civil Court. That is there. My only issue is, lordship, whether 12A has been compared or not, lordship.
Okay. And
lordship, he was relying upon the judgment point of view of the plaintiff. But you see the next paragraph, it says that Dhanbad. Lordship has got the Lordship has seen so many times, but I'm just, for my satisfaction, lordship, may kindly bear with lordship. Lordship, he was showing the conclusion part of the judgment, where the Honorable Supreme Court has concluded, in light of the aforesaid discussion, we summarize our finding as under paragraph 62 onwards. He was on paragraph 62F.
Yes.
He was on paragraph F, that the test for urgent interim relief is of an examination of the nature and subject matter of the suit and the cause of action. The prayer of urgent interim relief by the plaintiff could be said to be contemplable when the matter seen from the standpoint of the plaintiff. So what is the standpoint? There was no interim order. What I understood, lordship. Now see next G. Courts must also be wary of the fact that the urgent interim relief must not be merely on unfounded excuse.
Correct.
So these are, lordship, my small reply to this explanation, like why interim order was not extended, why there was no interim order. I've shown you all the lists.
Yes. Yes. Thank you.
This is GS6. Now, if I say that the lists, the copy of the list which were handed over, I'm not very sure whether the court was sitting or not, but it's obvious there's an urgent determination to some other court. That is the reason urgent determination is given to some other court. Now, for this interim order extensions and others, that's obvious, number one. So if the principal court or the main court is not sitting, the charge court, what we call in the lower court here, the urgent is there. No argument is made on that, on that regard. Second is, it is not my only case. If you read the plaint, it is not my only case that because of the interim order is not there, my urgency has cropped up. That is one of the reasons that fell from the court on the last day. When there's an interim order, why did you move this? My plaint is on a different, I stand on my own legs. My urgency is on my own legs. I say pleadings are there. I say that he is enjoying these, in not entering me and not allowing me to enter the property, third party interest and other things. So it's not only dependent on his interim order. So this is on GS6 is concerned. Because the injunction I enjoy with regard to a conference room in the second floor. Now there are other applications also, if these are small applications. Now GA5. GA5, now she will really take GA5. GA5 is my small application with regard to an amendment of the plaint, which was filed in prior in point of time. Now, Lord, she will kindly take the papers once, my lord. The amendment which I am seeking. Kotha amendment ta bolo? Yes, page 16. The GA5. So, GA5. This is page 16. Lord, she has seen the correction in the cost title, page 16. This is the only correction I want. because I could not, the plaint could not be, summons could not be served. In any event, my lord, the plaint and injunction has been served on them. Once I got the order of injunction, compliance of 39 has been done. So everything has been served. So, and they have entered appearance and filed vokalatnama in the suit registry. It is not that they have entered appearance in the general application. So they were well aware of the suit and they have entered appearance in the suit. Yes, we have inquired, my lord. Lordship can ask for a report from the department. They have entered appearance in the suit. Till date, there is no written statement. That we'll deal that when it comes. So this is the only amendment I am seeking in GA16, a formal amendment, so that the summons can be formally served.
Yes.
So this is GA7.
Yes. GA5.
Sorry, GA5. Sorry. GA5. GA7, GA5. This is the only amendment I am seeking. Well, it's a typographical mistake, if I may say that that word has gone down as defendant. It should be plaintiff.
Yes. Then
now, as a counterblast to GA5 came GA7, which is dismissal of the suit once again for non-service of writ of summons. So after we served them this is, so the GA7 is a, এটা কত? এটা GA কত? হ্যাঁ? এটা লেখনি কেন উপরে? হ্যাঁ? GA7. So GA7 is the counterblast to GA5, which is for, they say that dismissal of the suit for non-issuance of writ of summons. So writ of summons could not be issued for that small typographical mistake. And
when you filed the suit?
The suit was filed.
When it was presented?
Yes, there's order sheets are there. Lordship will see. I have presented, but I have the suit file. The filing date is 13th of June.
18th June.
13th June 2024. I have the case status with me, my lord, from the internet. Date of filing is 13th of June 2024. My lord's order by which I sought a leave under 12A and order to rule 2 is 18th of June.
18th of
June.
No, when it was presented?
18th June. My lord's order of 18th.
Correct.
Yes, the separate order of 18th June.
Correct.
18th June. And thereafter, I've moved the injunction application, which is GA1.
Correct.
Which is pending. Now, GA2, 3 is the other applications by the defendant. Other applications.
When you filed the GA7?
GA7. No, GA7. GA5. But GA5 was filed. There is a delay, Malad. We have prayed for this delay, Malad. For that prayer, it was filed in
14 July.
Yes, it's after a year. I must say I sought for a delay be condoned, Malad. I have given a reasonings also, Malad. There are explanations given also, Malad. I'll kindly see.
What is the status of the suit at present?
Present summons not.
Where is the plaint?
Plaint is plaint is.
वो हो गया.
Plaint है.
Rectify हो गया. Scrutiny हो गया.
हाँ, yes.
6th March. When you filed the application?
July. Sorry, Malad.
July.
Madam, sorry. But when GA1 was filed, we have served the plaint on them. But the service also has a mistake of that.
After इसके बाद क्या ये प्लेस हुआ था मेरे पास? ये रिपोर्ट? क्यों? नहीं क्या रिपोर्ट तो? ये तो 6 मार्च का है. इसके बाद क्या हुआ? इसके बाद क्या ऑर्डर हुआ?
No, one order. I have a bunch of orders with me.
After 6 March, what order passed?
6th March.
After receipt of the report of the master.
6th March.
25.
6th March. 7th March.
7th March order is there?
Yes, may I hand over? I can দিয়ে দিন পরপর order আছে পরপর সাজানো আছে order গুলো
7th March.
This is 7th March order. পরপর আছে I don't think when this
no. Why it is not placed? ये क्यों नहीं आया मेरे notice में?
But the applications were heard.
Why this report is not brought to the court? This is of 6th March.
এটা অনেক একবার ওঠো It is 7th March. Let the matter appear on 6th March. Typographical. হ্যাঁ সে আমি বলছি ও 6th মে হবে ওটা the 6th মে ঠিক আমাদের GS7 টা কোথায় হ্যাঁ এটা আমাদের তো
So why you not mention once the report has come on 6th of March? Why you not mention the matter?
report we were not I mean
Why you're once you find that there is a defects?
আমাদের GS7 আমাদের so for the
I pointed out.
দাও না GS7 no it is my learned friend's application is after my application.
No, that I will deal with that subsequently. Because it is the duty of the plaintiff to see what is the stage of your where is
yes,
your plaint.
yes
Correct.
yes
And it is the master you or your junior
yes
or
that's
whatever it is
we are
shall
the it's
appear.
our responsibility.
So it is your responsibility. Once on 6th of March the report has been submitted, why you not mention the matter here for taking appropriate steps for rectification of the defect, or where is the steps you have taken for rectification of the defects after 6 months?
Malad, as far I remember, Malad, after when the general applications were taken up, in one of the applications during the hearing, I personally remember that I brought this matter notice to the court. Even I requested, if my learned friends allows, we can correct it on a oral mention, because only that typographical error was there.
No,
My learned friend objected.
There are six defects. There are 6 defects, out of which 1 defects which you have filed the amendment.
Others, I believe, Malad, those can be corrected without an amendment.
Where is that?
Other 6 defects. Well, others, I believe, can be corrected without amendment.
Amendment.
But only the plaintiff and the defendant has to be amended formally. That
No, the typographical error in the affidavit under order 11 rule 3, then you cannot without the leave of the court.
The same problem.
Affidavit cannot be rectified without the leave of the court. Where is the plaint? Give the plaint.
I think the same cause title got repeated in all other pleadings.
No. The second, this advocate on record has not signed the list of documents as per order 11 rule 1 and 2. Yes, there is no signature. They are not rectify that. Then 3, annexure F of the plaint. Where is the annexure F?
Those corrections will have to be done, but I don't think amendment is required for those corrections. Plaint nahi. Plaint nahi kotha. Plaint kotha annexure hai. Fine, I'm beyond it, man.
Yes, next.
But we will have to other corrections. We will have to do it because maybe some glitches on the part of my advocate on record. But those 5 other signing and portions.
That's why when I find that due to you persons are not going to the office and not making the whatever the correction in the plaint which have been pointed by the department, that's why I have given a circular to the office. If any defects have been found by the office, immediately inform to this court, and every report is coming to this court, and all the advocates are taking leave from this court. Otherwise, 2 years, 3 years, it is pending before
with those defects.
My friend was only on the extension of interim order. That he was remembering every time, every hearing.
Next,
this leave has to be seeking Malad for because this amendments is there for so far my GA.
What the juniors are doing in this court of every chamber? Senior is appearing sitting with the senior only. What the advocate on record is doing? 6th March, now we're on September. 6 months passed, nothing, no mentioning, every time extension. I will dismiss.
Grateful.
Now, Malad, only thing, Malad, the defects which are there, my lord.
Let the advocate suffer. I also put the cost upon the advocate on record who has not taken his step. Why the plaintiff should suffer?
It's my fault.
What fault? Every time one or the advocate is coming and my fault. 6 months has been, 3 months has been passed, you have taken, and your senior is arguing the matter on merit. Your plaint has not yet been rectified. And they have filed an application for dismissal. What is your defense in that? What is the defense? They've taken, rightly they have taken out the application. Six March ये report प्लेस क्यों नहीं हुआ? हाँ? 6 March का है. List of defect 6 March का है. देखो कब है. Yes, next.
My lord, I should own up the responsibility was why I'm arguing the matter, my lord. I cannot give any explanation or excuses. That is the only thing. I was only told that plaintiff and the defendant. Maybe the cost battle in my dictation only that has gone wrong.
That's correct.
That's maybe on my dictation it has gone wrong.
Other side will raise any
Yes,
objection on that.
that's maybe my, because
problem
other
is-
defects are,
Other defects it has not yet been cured.
because there are 6 defects what I
Yes.
find, my lord. It's a mistake. No, but for the
It is not cured.
client should not suffer, my lord, for our mistake, my lord. I also tender my apology, my lord, for this. And the next time I will see that.
Okay, anything further?
And so far the GA 4, 5 and 6 are, sorry, GA 5, 6 and 7, these are the submissions. But if these can be disposed of first, then we'll come back on the other applications, because then the things will, because other applications, the GA1 is my injunction, GA2.
GA2 and GA3, one is section 10.
Oh,
And
GA2
that is
is section 10 and GA3 is order 39 rule A, 223A
Suggestion.
for non-service within 24 hours.
Yes, what is
Those
the
can wait, my lord.
It is pretty sorry for GS6, my
I
I
primary.
will decide these 3 applications.
With 3 applications. My lord.
7 is my application. Only on that
Only.
score, that plaint was filed on 13 June.
No, that is said
2024.
to your lordship.
Till date, we have not received any summons. So they're sitting
No,
tight
they
over
have,
the issue.
but only another thing,
And
my
one
lord.
after another, sir,
They
I've
have-
not interjected.
Sorry.
One after another, they went for
Okay.
extension,
Uh,
joined the injunction.
Learned counsel for the parties have concluded their argument in connection with GA5, GA6, and GA7.
GS7, my application.
GA5, GA6, and GA7. Full stop. CAV.
Great.
Yes, next.
But I appear for the receiver, Mullah. But I am appearing for the plaintiff.
Yes.
As per the last order,
My lord, I appeal for the defendant today. My lord, before the plaintiff starts, I wish to bring to my lord's notice that there has been a change in the advocate on record on behalf of the defendant, my lord. Now, the defendant is already suffering a direction by my lord
You are appearing for?
for the defendant. My lord, I've been instructed to appear for the defendants because the new advocate on record is yet to receive the entire record and the no objection, and it's file its wakalatnama and the competency. My lord, today all I seek is the leave of my lord to file my wakalatnama and competency and come on record. Now, good, bad, indifferent, my lord, today where we stand is defendant's right to file its written statement has been closed. Now, there is an injunction, my lord, direction has been passed. The special officer has, I believe, taken a possession of the property.
but I'll point out 2 things. That on the last visit of the learned receiver, what has happened? Alert, on the first day, on the property which has been attached by your lordship, he had put up a notice that it is under symbolic possession. He goes on the second day, he finds that the notice has been torn apart, thrown away. A padlock is already there, put up by someone. When he goes this time, he again finds the notice has been torn apart and the padlock is there. Malad, in this event, he cannot take the inventory also what is there inside. Malad, now, Malad, since Order 38 Rule 7 your lordship is aware of, Malad, the attachment will proceed in the nature of an execution proceeding.
I would be praying today, at least let the receiver take and make an inventory by breaking open the unknown padlock. He has already put his own padlock. Let him put his own padlock thereafter. Seal the premises.
No, his padlock is there.
His padlock is there, and there is a third party padlock.
Who has put the padlock?
That's what I, my
May I
lord,
address,
today,
my lord?
when the matter, my lord, the brief came to me, I instructed that the defendant should have disclosed a lot separate facts that were already pending. But there is a surface proceeding already pending. My lord, today
Who has put the lock? I am putting.
I believe
I am not concerned with the surface. I am not. This court has passed an order. The special officer has put the lock. Who has put the another lock over and above the lock put by the special
today,
officer?
as per my instruction, my lord, the defendant is not responsible for that because I believe
When your defendant will come and file an affidavit, he has not put the lock. Then I will direct my special officer to
on
go
that,
and
my lord. On
go-
that, my lord, today there is a GA3 pending, my lord.
I don't know.
Let
First,
me-
your client should come and say an affidavit and give an undertaking. I will record this statement. He has not put the lock, the over and above the lock of the special officer. Therein, I record the statement and I will direct the special officer to go and break open. Yes. That's all. Simple city. This court is not going to all other procedure.
I bow down,
Simple
my
city
lord. I bow down,
procedure.
my lord.
If you are telling that your client has not put any lock over and above the lock of the special officer, come and say and give and file an affidavit. Then and there I will pass an order.
If I may suggest, my lord, in this way, let me come up with an affidavit.
You file affidavit. I will give the time to the affidavit. But
against
only with
GH.
regard to if the special officer is appointed by this court and the court is the court's officer. If you are above over and above the court's officer and put another lock, then the court has to take its own recourse.
Absolutely, my lord. I bow
And
down
this
to
is
that.
the last court.
I bow down to that, my lord.
And for
Absolutely.
12 to 15 occasions, they don't appear. But after the first advocate had appeared.
That is the difficulty, my lord. In spite of that, today I am
not
appearing.
who is
before the
appearing.
court.
I am not seeing the face of any person. Only first you tell me I got the report from the special. I am not on the statement of the petition advocate. I am on the statement of the special officer.
Yes.
It is correct. There is a padlock over and above the padlock of the special officer. Tell me who has put the. If your client has put the padlock, come file an affidavit, give an undertaking. Yes, I have filed and I have put the lock. Then I will see. Then I will send the special officer to break open. If you say no, you have not put the lock, then I will refer the matter to the CID.
My lord, let me get back with the instructions.
No, come go at 2 p.m. Come at 2.
Yes, Lordship.
Yes, my lord.
Come at 2
Yes.
p.m.
May I file the report, my lord, in the of the last.
Come at 2.
They go on with
Take instruction. If
Yes,
you're telling, then let he come here with an affidavit.
Absolutely, my lord. Whatever is there, they should come up.
If say
right?
yes, I have put the
Yes.
then so if he'll say if he'll not put he has not put the lock, then appropriate action will be
My lord, today the defendant is not running away in spite of all these.
not running away. I am not telling that to give the property to the plaintiff. I am only with regard to the who has put the lock over and about the special officer lock, who has put the lock as per the order passed by this court.
Yes, my lord. Absolutely.
When the property gets attached, they come running before
Correct.
your lordship.
Let they come.
My lord, today also I am disclosing that there is surface proceeding already pending. My
Maybe-
lord. That also I need to
maybe.
disclose before my
Why
lord.
you not disclose when the order is passed? Why you not disclose? You are advocate. Why
And
not
it was
disclose?
not
And it is
attached.
not your plaintiff was with the family in the room when the special
Yes,
officer was
in-
there,
My lord, in the other flag.
and he has knowledge
flag.
the property is going to be sealed, but he has not taken any steps.
Let me get
Leave
back to
aside the other
instructions.
advocate, the earlier advocate,
Yes.
Let me get back
and
to
not
the
one property, 4 property. I remember all the things.
My lord, in fact, my lord, we are yet to receive the entire brief and.
I will brief you. I will brief you. I will brief you the case of the defendant. No problem.
Let me get
But
back to the
first
instructions.
this matter is to be solved. Who has put the lock?
Absolutely. Let me get back to that at 2 p.m. my lord. Grateful, my lord.
I'm very sorry, madam. Item 10, the interim order, the interim order is still 4th. Thursday.
Order is
Item
extended.
10. I'm sorry, my lord.
Extended till
Item 10.
till
That was CAV.
No, that was made CAV.
that is not the interim order.
No, that is not useful.
That
No, it was till 4th. The interim order is till 4th, Thursday.
the interim order is extended till 15th of September 2025 or until further order.
Whichever is. And the
Until
other
further order, whichever is earlier.
depending on order pass away.
Depend upon.
Item number 14, if I may mention, my learned friend is here.
Right.
I've just received his affidavit in opposition 2 days back, seeking an extension of filing affidavit in reply for 7 days.
14.
14.
As per the prayer made by the 14, huh? As per prayer made by the counsel for the defendant.
Defendant petitioner. Defendant petitioner.
Defendant. Time to file affidavit in reply is extended for a period of
1 week.
For a period of 1 week.
Well, I'm filing my opposition, my lord.
Affidavit in opposition filed by the plaintiff be kept with the record. Release the matter on 17th September.
Great.
Yes, call the fixed matter.
Item number 6. On the last occasion, my lord was kind enough to direct to issue warrant of arrest warrant against the non-appearing individual. My lord, he is there. I have instruction to appear on his behalf, my lord.
On behalf of?
On behalf of the, my lord,
Postman.
Dotto,
Hmm.
who was, my lord,
Postman.
arrest warrant was issued because of his refusal to accept. My lord, he is there, my lord. My lord, what has I have gathered from him that he has retired since 2024, my lord. 1st April 2024. Thereafter, he was called. The address mentioned in the notice was different. That is the reason he refused that. My lord, that cannot be a cause, but that was the actuality of what has happened, my lord, on that particular date, which culminated into his refusal to accept its appeal.
My learned friend is appearing for
Postal authority.
The postman.
Beat postman.
The beat postman.
My lord, if my lord may, I have a copy of a departmental communication wherefrom it will be apparent that he retired on 1st March 2020. May I
let it be put by an affidavit, my lord.
I have no issues with that, my lord, but that was the reason, my lord.
Okay, and another you continuing the cross examination. Okay, I will see to that. I will pass him.
My lord, and also seeking leave to file the wakalatnama.
File.
My lord, because.
Okay, I will grant. Let the cross examination complete.
But the second witness should be outside the court.
He should be. Wait outside. I will pass appropriate order.
Your lordship, but we have to.
Or lordship can release him.
Okay. Record an order.
But your lordship, he has served. Your lordship, as per his report, he has served.
What?
On the address, Jayjut. Kindly see the record.
He can make submission merit.
That is the. Who has produced? No, where is the police officer?
Police officer. He perhaps just went out. Bolam paide jete.
Which police station? Which police station? Officer in charge. Warrant officer of Nihati police station has produced Mr. Manoj Kanti Datta, beat postman, Nihati sub post office under arrest in terms of the order passed by this court. Police stop. And advocate, what is the good name, sir? So appeared on behalf of Mr. Manoj Kanti Datta and submits that he retired from the post of beat postman.
Postman with effect from 1st March 2000. It is an internal document.
With effect from 1st March 2024. Full stop. He submits that he has superannuated from his service and the summons reached to his place, but inadvertently he refused to accept the same. Thus, he prays for apology for not accepting the summons issued by this court and prayed for release him.
Your lordship, I need to intervene, your lordship, with your kind permission. Kindly see the additional judge's brief, your lordship. On page 11, it is written that the consignment number EW42712-124IN was delivered on 29 September 2024. If he has resigned on, he has a...
September.
Yes, resigned. No, that is
March.
This is regarding the arrest warrant.
March 2024.
20.
কি বলছি?
Your Lordship, then how he is
Praise for
serving?
apology and praise for release him on personal bond. Full stop. Had the learned counsel for the arrestee, Mr. Manoj Kanti Datta. This court find that he has already been retired from the service on 1st of March 2024. 1st March 2024. But as per the warrant issued by this court, he has brought under arrest. In view of the above, in view of the circumstances, Mr. Manoj Kanti Datta is released on personal bond with the direction to appear before this court as and when required by this court. As and when required by this court.
Let him file an affidavit disclosing this thing.
The Mr. Manoj Kanti Datta is also directed to file affidavit disclosing the circumstances due to which he has not appeared before this court on the date fixed. Within a period of 2 weeks. Within a period of 2 weeks.
But I will also ask if, my lord, now any of the party servers a copy of the cost title, it will be easier.
Within a period of 2 weeks from date. Full stop. After serving the same to the learned counsel appearing for the parties. Learned counsel appearing for the parties. The counsel for the petitioner. Who is appearing for the petitioner?
For petitioner.
Petitioner. Counsel for the
Plaintiff, Your
petitioner.
Plaintiff, actually.
Plaintiff/petitioner is directed to serve the copy of the contempt application.
There's no contempt application as such.
It was arising out of the July 29th order.
To supply the cost title of the case to the learned counsel appearing for Mr. Manoj Kanti Datta to file appropriate affidavit as directed above. Directed above. Okay. Yes.
Manoj Kanti Datta can go outside.
Yes.
The court.
We have to do his
The report submitted by the Deputy Sheriff of Calcutta, we kept the record.
that who you are doing, no? You have completed.
But inform your client, he should present on the next date or today, whatever it may, let he wait outside. If the cross examination is over, then he's.
No, this date only. Your Lordship, we will conclude.
Affidavit come because I think plaintiff has raised certain valid points.
Okay.
Let the affidavit come.
But kept in mind, whenever the court will, you are appearing and I am granting time. The learned advocate appearing for the Mr. Manoj Kanti Datta is given liberty to file wakalatnama within a week in the department, within a week from date. Yes.
Well, let him go out because some questions will be common, my lord. So last দিনের ডিপোজিশনটা একটু ওনাকে দেবেন।
Witness কে?
Yes.
Well, last day oh witness কোথায়?
Come on, doc. Come on, doc.
What is your name, sir?
Ranjit Chakraborty.
Ranjit Chakraborty. Spelling?
RANJIT
Chakraborty.
CHAKRABORTY.
লাস্ট দিনের ডিপোজিশনটা।
Yes, sir.
Mr. Chakraborty, no?
Ranjit Chakraborty.
Witness, please look at your last day's deposition. Question number 14.
Number 14.
Page 3.
Yes.
Please tell my lord, you have said you have reached the registered address. How do you know? How do you know that was a registered address?
My lord, please accept my humble respect. Generally, the registered address is identified with the help of local people. We made inquiry and some local people showed me and I entered the premises of the registered address. Through a small passage adjacent to a large gate. Last day,
Adjacent to a large gate. Yes, sir.
I have already mentioned last day.
Yes.
এটা কি জিনিস? না, এটা হচ্ছে supplementary. Supplementary. G1. Okay. Witness, please look at these two photographs. SA2. Did you find SA2?
SA2, yes.
What is the name written on the gate?
Gajmukh Binimay Private Limited.
Right.
Gajmukh Binimay Private Limited.
Right. Now,
Binimay. B. Private Limited.
now, do you find any small gate here?
Definitely there is no small gate, but I am sure that a small gate.
No, the first
Yes.
question, give the answer, then you
Okay,
can give
okay,
an whether there is any small gate appearing in the picture or not.
No, there is no picture.
Then you can give and whatever you want to say. No, there is no small gate, right? No, there is no small gate in the picture, appearing in the picture.
The picture is shown. There is no.
Correct.
Wood paper দেখে দেখি পিকচারটা পুরো গেট ছিল না Please look properly. There is a small gate. Can you find it?
I mean that this is not the small gate. This is the large gate, and there is a part. I mean
one person to enter.
I mean a small passage adjacent to the main gate. Adjacent to the main gate, and so I can say, calling on my memory.
I can calling on my memory
that there existed 2 or 3 small passages adjacent to this large gate.
There existed 2 or 3 passages adjacent to the main gate.
If the picture covers the whole area, the passage will be visible. I am sure.
I am sure.
Now,
if I stand before in front of the gate, the passage will be in the left side. So far my knowledge is concerned.
So far my knowledge is concerned.
Now, witness, please come to question number 1 on the last question. Please read the question and your answer.
Please tell to the honorable to court the description of the place where you served the summons. Can you describe it? For example, there is a small gate or
white gate, or as you entered, whether there was office or there was, read it in your, read it aloud, read it in your mind.
वो लिखो मत, don't to write. Shown question number shown.
Now come to question number 15. Have you gone through the question? Now, you will find that you were asked to describe the place where you entered, and you said, I am just now unable to describe it on the last occasion. But today you said there are 2-3 small gates.
On the last occasion, you stated that you are unable to describe. Now today you are telling that you are able to describe the gate.
I say I can say calling on my memory. The matters was discussed that day, and memory recalled to me, and that's why I am describing this. Again, look at question number 18. You are specifically asked, you visited place, but you cannot describe the place. And you said, I have stated everything in my report. Yes. So you say you cannot remember. Now, look at a document being SA3, supplementary affidavit.
Right.
Do you find a gate? Yes, yes, I see. The address is same. Address, who is address? The registered address. Is it?
উনি জিজ্ঞেস করছেন কোন অ্যাড্রেসটা সেম জিজ্ঞেস করছেন
The other আগের ছবির this is not the same address. There are 2 gates in the same premises. Do you recall? I cannot recall it.
I cannot recall it.
I'm suggesting to you that there are 2 gates in the same premises, but you entered the not the gate of the defendant.
আপনি প্রশ্নটা বুঝতে পেরেছেন তো?
As per identification of the local people.
As per identification of the local people. Yes, sir.
I entered the premises. He has been person knowledge. Of the registered address. The defendant company. Now, once more look at the picture being SA3. Yes. You will find the name of the defendant. Joy Jutes and Industries Limited. You have found the
Joy Jutes and
Industries Limited. And you will also find the earlier name. Gajmukh Binimay Private Limited. No. Same. SA3. SA3. You'll find the older name there formerly.
Former name. আগের নামটা কি ছিল সেটা বলুন।
I don't know.
লেখা আছে তো।
Formerly. Formerly. Please spell out the name. Mills Co Limited, and first name is Nodia. NUDDEA. Nadia Mills Co Limited. Company Limited. Address and associate of. No, address. That's not the address. Kanthalpara, Noihati, But then in 24 PGS Parganas, not 24 Parganas.
Right. The plaintiff copy then. Good. Plaintiff. Please look at the plaint.
Writ of summon. Writ of summon.
Well, this is the advantage and disadvantage before a court who has knowledge of trial. Right. Right. So, can you look at the plaint? What is the address of the defendant?
Kanthalpara, Noihati district, 24 Parganas North.
So there is a gate in the premises with the name of the defendant. Do you agree?
I cannot recall it.
Conveniently.
Is this name?
Question টা বলো একবার।
Please repeat the question.
Do you agree? There is a gate in the premises with the name of the defendant. Do you agree?
ওই premises এ defendant এর নামে একটা গেট ছিল। এই সঙ্গে আপনি এই বক্তব্যকে সমর্থন করেন?
I cannot.
First বলুন আপনি রাজি না অর্ডার?
No, see, you have seen the address in the plaint,
Plaint.
correct?
I have seen.
And you stated that you went to the registered address. The question is that the gate which you have identified the address is the same which you entered.
I cannot recall what was written onto the gate.
Okay. I cannot recall what was written at the entrance of the gate.
I entered through this narrow passage.
As I entered through the narrow passage.
Adjacent to a large gate.
Adjacent to the large gate.
Writ of summons take to them. Kindly look at your service report in the writ of summons.
Yes.
Kindly look at the service report.
It kindly read that it is your case that the defendant has changed its name. It is now known as Gajmukh Vinimay Private Limited. Right?
So the defendant has changed its name. It is now known as Gajmukh Vinimay Private Limited. Yes.
Right. Now, I have shown you the picture being SA3. SA3. Which clearly shows the name of the defendant and its previous name, right?
Yes.
When you are in the service of the court, you are entrusted to serve the writ of summons upon the defendant. Now, if there is a gate in the name of defendant,
and there is a gate in the name of Gajmukh Binimay. There are two gates. How could you say the defendant has changed its name?
I came to know from the person whom I get acquainted into the premises in the office of the registered in the registered office.
How do you know that was registered office?
As per identification of the local people, I entered the premises and entered the premises and I got acquainted with one who represented the company Joy Jutes Industrial Limited.
So you had no personal knowledge.
Personal knowledge means
আপনি কি নিজে জানতেন এটা না ওই
no
ভদ্রলোকের কথায় আপনি
ভদ্রলোকের কথায়
মানে আপনি জানতেন না তাই তো
না I
No,
I have no
I did not
knowledge.
have any personal knowledge.
I have no personal knowledge. And I asked him to show his documents. He did not show any documents.
Asked him to produce his document, but he did not show
তে দিতে পারে।
He only represented the company.
I think FD থাক। আর দরকার। Personal knowledge নেই তো আর কি হবে? I'm suggesting to you that your report is incorrect.
No.
I do not agree.
আচ্ছা আচ্ছা।
বলে দিন I
What
do
is
not
your
agree.
answer? He's telling that what the report you submitted here is incorrect.
No, the report is correct.
I disagree. The report is correct.
Even one who I obtained an endorsement with full signatures of the receiver.
Yes. Next.
And there was a stamp discrepancy happened and I have given my explanation in my report.
What was the discrepancy?
Discrepancy named in the name of company.
Please explain.
The defendant company name was Joy Jutes and Industrial Limited and the stamp there was Gajmukh Binimay Private Limited.
So,
yes.
Can you name this person who received this?
I cannot see.
Yes,
I cannot read it now.
You didn't ask his name, the recipient?
Yes, but I cannot recall it.
Okay.
Yes, but I cannot recall it right now.
That's all? That's all. Lordship, guide me half a minute.
Explanation because they will discuss
Is it not your duty to mention the name of the recipient in your report?
Actually, we have no training about the service.
Training about the service. Yes, sir.
Or about the service of process.
Training that's all.
And
Now
you learn from the senior.
Now you want that a good circular is to be issued by this court with regard to the
regarding the SOPs, your lordship, regarding the SOPs, that this has to be checked.
I cannot ascertain to the learned court what I should do and what I should not do.
Okay. I cannot ascertain what I should do and what I should not do at the time of service of summons.
That puts an end everything. And my lord, can we pay him cash? I mean, nothing to be mentioned.
Paid that day, your lordship, for his lunch and conveyance.
You have paid.
That day we have paid.
Okay. Wait.
Yes, that's all.
That's all.
Your
Lordship.
No point repeating, my lord.
Okay.
May I start, my lord?
You can start.
Mr. Chakravarti.
Yes,
We'll
yes.
take only two, three questions only. Mr. Chakravarti, can you tell me,
Cross examination by the plaintiff.
Mr. Chakravarti, should I talk to you in English or in Bengali? Which is comfortable to you?
I am Bengali.
আচ্ছা শুনুন, আমি আপনাকে বাংলায় জিজ্ঞাসা করছি, পাতি বাংলা। আমার একটা কথা বলুন মিস্টার চক্রবর্তী, আপনি যখন গেলেন টু সার্ভ দ্য সামন, আপনাদের সামনের উপরে ঠিকানাটা লেখা থাকে যেখানে সার্ভিস করা থাকে, সেই ঠিকানাটাতেই আপনি গেছিলেন?
একদম। Registered address is most important to my in case of limited company.
Just a minute. Yes.
So it was
Question
written,
likhni hai?
it was
When you went to question Bangladesh.
English, in English.
Good.
Have you served the summon on the address which you were designated to deliver?
Yes.
Yes. Next.
Mr. Chakravarti, how did you serve the summon? ওটা কোয়েশ্চেনটা করা হয়েছে, তাও আমি আবার আপনি কি করে ওটা সার্ভ করলেন? ফিজিক্যালি গেলেন, গেটে ঢুকলেন, you entered the gate.
Got acquainted with one.
Just a minute. Let you put the question, man. Let him give the answer.
It cannot go.
I have mentioned, I have explained, but I have stated everything what happens on that day in my report.
I have explained in my report what has happened at the time of service of writ of summon. Yes.
Now, Mr. Chakravarti, can you answer me? The person who received the summon from you, he has signed on behalf of Jayjut.
Yes, yes, he has signed on behalf of Joy Jutes, but one officer, I get acquainted with one officer who represented the company, but he got the summons and the extra documents received by
Security office.
one who put the signature and endorsement there.
Mr. Chakravarti, did you ascertain that the recipient was an employee of Jayjut Industry Limited?
Yes, because he acknowledged the responsibility by putting his written statement there in the read of
Receiving.
the summons.
Responsibility?
Yes, he has taken the responsibility while accepting the writ of summon and putting his signature in the writ of summon.
Mr. Chakravarti, did the
Just
same...
a minute. Yes, no, continue.
Mr. Chakravarti, did the same person affix the stamp on the document?
The person who received, who put the
Correct. The person who signed, he has only put the seal. Yes.
Your Lordship, kindly note.
That's all.
I will. Mr. Chakravarti, when you entered the gate, can you recollect what was written on the gate, the address, or the gate was open? You cannot.
What was written on the gate, I cannot recall it.
You cannot recollect what was written on the gate.
Is it possible, Mr. Chakravarti, that the name on the gate could have been painted afterwards, after your service?
I cannot say it.
You cannot say it. Why you were not been able to see the name on the gate, Mr. Chakravarti? Can you please explain?
Actually, I was trusted with the registered address as per identification of the local people. And when
identification of the local people, both sir. Yes.
And when I got acquainted with one who represented the company,
when I got acquainted with one representative of the
When
company.
I acquainted with the registered address from the local peoples of the said locality. ঠিক আছে তো?
Mr. Chakravarti, Now, can you please tell me, you have written in your report that subsequently he is found to talk that the name of the company has changed.
Yes, in my presence, he talked to someone about the process.
And after that, they signed in your.
In my presence, he had a talk someone else over phone.
To someone
Correct.
on to his upper hand.
Correct.
Said yes. And
Then
after that,
thereafter he has received the summon and put the seal.
Mr. Chakravarti, it didn't occur to you that he is signing on behalf of Jai Jute and the stamp he is fixing is not of the same company.
yes.
Have you questioned him about this?
Yes, I asked him. He said that the present stamp is not available.
My lord.
That's all.
But they sign on behalf of the Jai Jute.
Yes, he acknowledged the responsibility, putting his written statement there.
Mr. Chakravarti, have you asked him who is he? What was his designation?
Who is he? Or what was his designation?
He said that he is one of the officers.
He said that he was
One of the officer of Jai Jute.
And he just told me his name, Agarwal.
He is officer of whom?
Officer registered company.
Of the registered company. And he
disclosed his
he disclosed his name as Agarwal, inward comma.
My lord, he was given impression that he is signing on behalf of
Yes,
Jai Jute.
it has come.
Mr. Chakravarti, do you have any process, how you serve? Is there any process which you have to follow? What is the process of serving the summon, which you follow, which usually is followed?
Generally, we get acquainted with the addressee and awaken him to the sum and substance of the writ and or summons or notice, and he or she with his full knowledge received the copy of writ of summons, and as a token of acceptance he put his endorsement.
Okay, no acceptance. He put your
Acceptance report.
Mr. Chakravarti, in your statement you have written, I awaken him to the scene and substance of the writ of summon by reading it out loudly.
substance of the deed of summons.
Yes.
You explain to the person whom you served.
I have mentioned it in my report too.
That is why I am asking you, Mr. Chakravarti. You explain it to him.
Yes.
Clarified.
Yes.
That you are serving for Jai Jute.
Yes.
And they accepted it.
Yes.
That's all.
Well, if this already, I do not want to waste the time of the repeated.
Yes. You will examine the other witness.
My lordship, if it can be concluded today, your lordship.
You will examine.
Not today, I have to get ready a little. But
Your lordship, it is, and then kindly make that in the next occasion it is concluded, your lordship. It is
fixing it.
before vacation, your lordship, if it can be.
Before vacation, the witness is present. Examination in chief and cross examination is concluded, and witness is discharged. The second witness is brought on arrest and is released on personal bond. Counsel for the defendant submitted. He will examine the said witness on the next date fix. Let the matter appear on डेट है बिफोर वैकेशन कुछ है एग्जामिनेशन के लिए 19 सितंबर और 12:30 19 September 12:30
12:30
for examination of
well, only one thing. I'm sorry.
Yes.
Lordship, dictating.
What is the name? Minal Kanti. What is name?
Minal Kanti Dotto.
Manoj
Kanti Datta. Manoj Kanti. Yes.
My lord, it is the case of the plaintiff that there is only one gate,
and it was subsequently painted with our name. Lordship appoints a special officer at my expenses to find whether there are two gates for limited purpose,
Case, Your Lordship.
at my expense.
That's correct, Mr. Sarkar.
That is
It
not my
the
case, Your
writ of
Lordship.
summons.
That is
Higher-
not my
The
case.
court will decide. That-
Already good service, Your Lordship. As per the post office report, it has been served.
Uh-huh.
And this is not my case. There is one gate or two gate.
Then this is later.
The question was asked whether the gate has been painted afterwards. So, Mala, to get
See,
clear the
court has to
confusion.
decide from the
Do not
writ of
waste the time.
summons.
Lordship.
It is admitted that it has been served to
On
purpose-
Gajmukh Binimay.
Gajmukh minimum seal is there. Let
Your
the
Lordship, the signature.
let the from the examination chief and prosecution, let the court decide whether it is a proper service.
And the
or not.
signature is of Joy Jude, Your Lordship. Kindly.
It is admitted that there are two gates.
And he
Your
explained.
your case is also by the side. The another gate is there. So question of that, and he has stated that he went by this.
Side
Let
gate.
the court decide what is.
Very well. Very well.
Let you examine the postal authority where it has been disposed.
Actually, in the hearing, I'll show my lord, but not
Okay,
now.
next time you come.
Well,
Not to disclose your defense. now.
yes, well. Sorry.
Yes, next.
Number 12, I oppose
My
the
lord,
petition.
Item 12, I appear for the plaintiff petitioner. Will my lord grant a short passover? My lord, I'm on my way physically to my lord's court. My lord, will kindly grant me a short passover. I'll
Right.
come and address my lord physically, my lord.
A very
Very short passover.
I'm for the defendant number 1. But there was a series of proceeding that your lordship had heard. But goods were supplied to the defendant number 2. But I had issued a comfort letter that I will pay on behalf of the defendant number 2. Application was filed for judgment upon
That
it.
power grid.
Yes.
Arunachal on some.
Yes. Now I had filed an application for Order 7, Rule 10 because there was a forum selection clause. Application filed by the plaintiff for judgment upon admission. Both the applications were heard analogously and both the applications were dismissed. No appeal from the order. Now, Mullah, during the pendency of the suit, the defendant number 2, Mullah, he has suffered an order of CIRP. It has gone into corporate insolvency resolution process. Now, Mullah, they have included the amended plaint indicating the proposed amendments, where they have indicated that they want to implead the resolution professional instead of the defendant number 2. But this, in my humble submission, is impermissible because defendant number 2 being the corporate debtor having suffered an order of CIRP and moratorium in effect, the suit cannot proceed.
No, but the corporate debtor is appointed. Corporate is the resolution professional has been appointed.
Yes.
So he can deal with that.
No, but if he has any claim against the defendant number 2, he has an appropriate forum. He can go and lodge the claim before the RP. The RP will collate the claims. COC in.
Because when the CIRP was.
But the order is annexed.
When the moratorium was passed.
Yes, the order is dated, my lord.
Before suit or after suit?
No, post filing of the suit. My lord, kindly see page 9 of the order. The order is dated 4th of June 2024.
29?
My lord, page 9 of the application, 4th of June 2024.
This is my application. May I please it, my lord? The defendant number.
Let the overall will see.
But-
I am not disposing of without your hearing you.
Yes, kindly see the first page of the order, my lord, page 9.
Yes.
Orders pronounced in the result, this company petition is admitted as per the terms mentioned in the order. Moratorium is imposed. Interim resolution professional is appointed. Now, my lord, kindly see section 14 of the Insolvency and Bankruptcy Code.
Okay, he is not there. Come on then. Because he's
My lord, will kindly grant a short passover, my lord, 2 o'clock, my lord, if my lord kindly grants it, 2 o'clock matter.
Not today, tomorrow.
Not today.
My lord.
Yes, next.
But 13, my lord, I appear for the plaintiff.
Your Lordship, I am appearing for the defendant. Your Lordship, we were directed to comply the Commercial Codes Act and file all the documents, Your Lordship. I am at a loss, Your Lordship. I am praying for 1 week's adjournment, 1 week's time to comply with the Commercial Codes Act, Your Lordship.
New application that we have filed.
This is a GS7.
Okay, Lordship.
GS7.
Lordship, I am talking about the main matter, CS61, Your Lordship.
Yes.
GA7.
CS61, you are for the plaintiff.
No, I am
Defendant, Your Lordship, defendant.
So what you have, what order is passed in the
Your Lordship, to comply with the Commercial Courts Act to file the list of documents and other documents as per the Commercial Courts Act, Your Lordship.
transfer case?
Yes, my lord, it was transferred on 10th of December 2019. My lord, your lordship's order of 25th September 2023 records that. 25th September 2023, your lordship's order, wherein your lordship had recorded that suit was transferred by the order of 10th of December 2019.
Yes.
Now, my lord, post-transfer, my lord, we complied with the provisions of the Commercial Courts Act and my lord, all the formalities were done. Now, my lord, we filed an application in 2023 for disclosure of additional documents. My lord, that was allowed by your lordship because we had disclosed 3 documents, a settlement agreement and 2 correspondences. Now, my lord, the reason of disclosure of these documents is, my lord, it shows that the defendant has admitted my entire claim. Because I tell you, your lordship, my lord, claim suit filed in respect of my claim for goods sold and delivered. The defendant's defense was that he was, my lord, acting as a contractor in a plant set up by Adhunik, my lord, Adhunik Power and Natural Resources Limited. In the written statement, my lord, they have disclosed documents showing that if they receive payment from Adhunik, my lord, they will immediately release my dues. That was their defense. There are correspondence on their on record. Now, my lord, there was an arbitral reference between the defendant and Adhunik. The arbitral reference was terminated, award was passed. The parties, the defendant and Adhunik, entered into a settlement. So in terms of the settlement, my lord, all the dues of the defendant were made over or remitted by Adhunik. Now, I have written a letter to Adhunik whether the disputes have been settled, whether payment has been made. Adhunik responds that all payments were made to the defendant. So, if defendant says that once they receive payment from Adhunik, they will return my dues, my lord, my claim fructifies. But kindly see few documents. Lordship kindly takes, my lord, volume 2.
What document you want? What requirement you record to completed?
Your Lordship, to comply with the Commercial Courts Act to file affidavits in terms of the Commercial Courts Act, list of documents as well as other affidavits as relied upon by the defendant along with the. Yes, Your Lordship.
But what regard to the, what about the GS7? If you have received the all payment from the Adhunik and you have given undertaking after receipt of the payment from the Adhunik, you will make the payment. So what remains further? If you have received the plaintiff is having all the document that you have received the payment from the Adhunik in terms of the award passed by the arbitrator in the by the sole arbitrator or the arbitrator tribunal, whatever it may be.
In terms of settlement, Your Lordship.
So if why you are not paying the amount to the plaintiff?
Your Lordship kindly gives an adjournment. Then in that case, I will take instructions and come back, Your Lordship, because I don't have instructions on that.
But non-compliance, so far as the directions given by your lordship, is from September 2023.
Okay, that I
Now,
will
kindly see few documents, my lord, page 118 onwards. Page 118 of volume 1. In fact, lordship kindly sees, my lord, page 117 first. But this is a letter of 9th of March 2012 issued by the defendant, but kindly comes to the last paragraph, which starts with the sentence "in view of the above."
Yes.
In view of the above, we are accepting your documents under protest and your payment will be released only after receipt of payment from our customer, Messrs. Adhunik. We are once again advising you not to dispatch more items to Adhunik project account MacMed without our written confirmation. This is the first letter. And Mullah, this goes on. Mullah, page 118.
Okay, but they are asking time. When you will be ready, madam, with regard to the GS7?
Your Lordship kindly keeps it any day next week, Your Lordship.
They have not filed the affidavit.
No, Mullah, this is coming for the first time.
So you will not file. Have you received the GS7?
Lordship?
Have you received the copy of GS7?
Lordship.
So
I wish to file affidavit in opposition.
How soon you will file?
Your Lordship, 2 weeks time.
Well, in that case, let there be an interim order, Mullah.
What interim?
I'm only praying for an order of injunction. Mullah, prayer, page 12, Mullah, prayer D.
Let affidavit be complete. Plaintiff has filed an application being GA Comp 7 of 2025, praying for judgment upon admission. Counsel for the defendant prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. Full stop. Counsel for the defendant also prays for extension of time to comply with the provisions of the Commercial Court Act in respect of CS Com 61 of 2024. Considering the submission made by the counsel for the parties, the defendant is directed to file affidavit in opposition in connection GACOM 7 of 2025 within 2 weeks. Reply, if any, there to be filed within a week thereafter. The defendant is also directed to complete the process for complying with the provisions of Commercial Court Act in CSCOM 61 of 2024 within a period of 2 weeks from date. This is the matter. 3 weeks हुआ ना? This is the matter on 24th of September 2025 for hearing of.
Instead of 24th, can it be on 25th?
25th of September 2025 for hearing of GS7 of 2025.
Great.
Under the
Great for your lordship.
same. Under the heading adjourn motion.
Great.
Great for your lordship.
Next.
15 I appear for the defendant. Your lordship was hearing my application under Order 7 Rule 10. Well, this is that matter your lordship might recollect.
Yes.
That the lease agreement, unregistered,
Not registered.
insufficiently stamped. When we had filed the application, Deepak Polymer was holding fort, and as was your lordship's line of judgments following Deepak Polymer. On the last occasion, I had placed T. Thompson that even the division bench's order does not affect the facts of this case, because that was a case where there was a valid lease which expired by efflux of time. Ours is an unregistered lease which cannot be looked into at all. Well, that was one part of it. So far as dispute arising out of an agreement is concerned, that expression. The other expression that it has to relate to an immovable property used for trade or commerce. Your lordship will recollect, I had placed 1993 Supreme Court, the only Krishnan judgment,
yes,
which although rendered in the context of the Constitution, categorically says that educational institutions cannot be treated as trade or commerce within the meaning of Article 19. Well, it's similar analogy I wish to draw so far as 21C is concerned. Well, those are really my submissions. I will not unnecessarily waste the time. The KC Itub judgment, the Park Street Properties judgment, they have all been referred to in TE terms. I had shown your lordship the relevant
yes, that already there.
I'll only place the Commercial Court Act. Your lordship knows it all too well. Section 21C, that there is really two limbs to it. So far as suit for eviction is concerned,
yes,
21C 7, if your lordship takes, in this act, unless the context otherwise requires, commercial court means commercial dispute. Where under C means a dispute arising out of, now Roman 7 reads agreements relating to immovable property used exclusively in trade or commerce. So the two-pronged requirement is number one, the dispute has to arise out of an agreement, and agreement presupposes the existence of a valid agreement, which takes care of the first limb. And the second is it has to be in relation to immovable property used exclusively in trade or commerce, which also I have satisfied your lordship. And admitted position, I have shown your lordship the plaint and the 106 notice. Admitted position as per the plaintiff itself is that the property in question was being used for the purpose of running a school.
Yes.
And this is a primary school partially aided by the state government. This is so far as GA3 is concerned. I also have another application for leave to file written statement. There is an order passed by a coordinate bench in my matter by Justice Mukherjee that this application should wait the outcome of GA3, which is earlier in time Order 7 Rule 10. So these are my submissions so far as Order 7 Rule 10 is concerned. Whichever way your lordship decides, thereafter I will move my application for written statement.
Okay.
These are.
Yes. But today I don't think the time will permit.
Lordship has a 12:30 also. I finished as quickly as possible.
12:30. Other matter is there. Come on the next. Come tomorrow.
And tomorrow I'll be in some difficulty. My junior will be there.
Yes, he will.
They will.
Come. Counsel for the defendant has concluded his argument in connection with GA3, na?
Yes.
GA3 of 2023. Due to paucity of time, counsel for G20 could not argue the matter. Accordingly, case adjourned. Let the matter appear tomorrow under the same heading. Yes.
But the 93 judgment, I had shown your lordship the book. The copy is not there. On the next occasion, I will hand over. Great.
My lord, takes the next matter, my lord. Item number 16.
Huh?
Item number 16, my lord.
16?
Yes, my lord.
Yes.
It was dismissed, your lordship, on the ground, my lord, that no steps have been taken by the petitioner, by the plaintiff, my lord, to proceed with the suit. My lord, therefore, my lord, on the last occasion that different counsel was appearing as well, he was unable to assist your lordship with the actual facts of the matter, my lord. My lord, what has happened? If your lordship will take the order first, my lordship, lordship will find the order from page 79 of my application.
Yes.
Yes, my lord. Lordship will find the advocate who was appearing, my lord, he was unable to assist your lordship. What has happened? My lord will kindly take, my lord, the page 75, my lord, where summons have been issued. My lord has got page 75.
75.
Yes, my lord.
Yes.
Summons were duly issued, my lord. Accordingly, your lordship will also find from page number 77 the report, where, my lord, the defendants, they were unable to trace the defendant, and accordingly, a report was, my lord, furnished by the department. And thereafter, my lord, subsequent steps have not been taken by us. That is an admitted fact, my lord, and we tender our unconditional apology, your lordship, for that. Now, what was the confusion regarding this, your lordship? I'll indicate. Now, your lordship will kindly take, my lord, page number 12. Page number 12, your lordship will find from the MCA report the registered office of the defendant company, my lord. Now, my lord has got from page number 12 the registered office.
Yes.
Now, accordingly, the dispute arises of a lease agreement, which, my lord, kindly comes to page number 18 once. My lord, in the lease agreement, your lordship, lease deed, your lordship, this is a registered lease deed, where from page number 18, my lord will find the address, registered address of the 3.2, last paragraph, registered address is at 127 Bagpota Road. Now, my lord, summons have been issued in this address. And accordingly, since the defendant company is not operating its business from this address, your lordship, my lord, the summons were returned.
Who is appearing? You are appearing?
Well,
Yes.
Well, I am led by Mr.
My lord, I am appearing for the respondent in this matter.
Yes.
My lord, I do not have any objection if this is allowed, my lord. No summons has been issued to us. We have not received any copy of the plaint, my lord.
What was the confusion, your lordship, I have indicated?
So why you have not taken steps if it why
My lord,
when you obtained this report?
Yes, my lord. After obtaining this report, I should have come up with another application, my lord, but it was absolutely, my lord, our mistake, my lord, which
Yes, 2022.
Shy away from, my lord.
Registered address of 2020, incorporation date of 2020. Then, and you file the suit in 2024.
My lord, 2023, my lord, we have filed. My lord,
CS 24. 23, yes, 23. And the agreement, when the agreement was registered?
My lord, the agreement was registered, your lordship, will just indicate.
What is the date of the agreement? 2020.
2020. 23rd November, September
2020. That time the address was this one.
Yes, my lord. And accordingly, my lord,
so this is with regard to the defendant number 1.
Defendant, all the defendants, my
All
lord, they are the directors of the company.
Okay.
And, my lord, it was the specific case, my lord, that they are jointly and severally liable, my lord. That's why, my lord, they are being made a party.
The plaintiff has filed the present application, being GA-1 of 2025, praying for. Where is the order?
My lord, page 79, your lord.
Praying for a recalling of the order dated 13th June 2025, wherein this court has dismissed the suit on the ground that the plaintiff has not taken any steps for issuance of summons. Counsel for the plaintiff submit that after filing of the suit, the plaintiff has taken appropriate step for issuance of writ of summons, but the same was returned with the endorsement. Service could not be served upon the defendant of 128, and it was found that defendants were not found at the address mentioned on the original writ of summons. Counsel for the plaintiff submit that the plaintiff has filed the suit against the defendant at the address mentioned in the cost title on the basis of the address mentioned in the what is the lease agreement?
Lease deed, my lord, registered
lease registered lease deed, wherein the address of the defendant company is recorded as 127, Bagpota Road, Bagpota Road, Sonali Park, Sarsuna, Kolkata 70061. Counsel for the plaintiff submitted subsequent of filing of the suit and receipt of the report of the sheriff of this court, deputy sheriff of this court, the plaintiff has obtained details of master data of the defendant company, wherein it is found that the registered address of the company is changed as 26 capital A Babdana, Bhabana, page 12, Road, Kolkata. Full stop. Counsel for the plaintiff submit that as the plaintiff could not take appropriate steps for issuance of writ of summons at the new address, counsel for the plaintiff submit that as the plaintiff was not having the new address of the defendant company, and as such he could not take he was not in a position to take appropriate steps for issuance of fresh writ of summons upon the defendant. Accordingly, he prays for recalling of the order dated 13th June 2025, so as to enable the plaintiff for taking appropriate step for issuance of writ of summons upon the defendant at the new address as mentioned above. Police Learned counsel for the defendant raised objection and submits that writ of summons was returned in the month of October 2023. And since then, the plaintiff failed to take appropriate steps, and accordingly, this court has rightly dismissed the suit for not taking steps by the plaintiff, and as such, the application filed by the plaintiff is required to be dismissed. But the learned counsel for the parties peruse the materials on record. This court finds that immediately after filing of the suit, the plaintiff has taken appropriate steps for issuance of writ of summons, but the same could not be served upon the defendant, as the defendants were not found in the said address. Subsequently, the plaintiff has obtained documents from the website of the Ministry of Corporate Affairs, wherein the plaintiff came to know that the address of the defendant has been registered address of the defendant has been changed, and now the plaintiff undertakes that the plaintiff will take appropriate steps for issuance of writ of summons at the new address as appearing in the master data.
So great.
Consider the submission made by the counsel for the parties. This court finds that one opportunity should be given to the plaintiff for issuance of writ of summons, for taking appropriate steps for issuance of writ of summons upon the defendant at the new address which the plaintiff has obtained from the website. Considering the above, the order dated 13th June 2025 is recalled. Full stop. The CS Com 543 of 2024 within bracket old CS number 192 of 2023 within bracket Anurup Roy and others versus Red Eagle Entertainment Private Limited and others is restored in its original file. Full stop. The plaintiff is directed to take appropriate steps for change of the address of the defendants in the cost title of the plaintiff within a period of 2 weeks from date.
So great.
GA number 766 disposed of.
Obliged, my lord.
Yes, Pranava,
Yes,
accountancy.
yes, my lord. Your lordship gives me, lordship remembers, my lord, but if your lordship gives me 2 minutes, I'll just recapitulate with your lordship's kind leave, my lord.
Yes, yes, yes.
My lord, my case from the beginning, and there are two applications before your lordship, my lord. One is my application, one is my learned friend's application for judgment upon admission, my lord, and my application is for extension of time to file written statement with a copy of the written statement annexed to the application. And that written statement also has a counterclaim. My lord, earlier in this litigation, my lord, I had taken out an application for addition of party, which was rejected by your lordship, my lord. The division bench concurred with your lordship's view, but gave me one little breather that if my written statement comes in and I have a counterclaim, then I become the plaintiff in as far as my yes, and then I have dominus litis as far as the counterclaim, so I can implead parties. That was the little breather which the division bench gave me, my lord. Now, my lord, apropos my learned friend's application for judgment on admission, my consistent case has been that I am not the ultimate recipient or beneficiary of the funds which the plaintiff advanced to me. It was shown as an ostensible loan transaction, but it was actually meant to fund to fund one Mr. Raju Patni and his group of companies called Sagittarian. This was done in order for the plaintiff's promoter, Mr. Pradeep, to acquire shares of Lakshmi Vilas Bank. So since he was promoter of Lakshmi Vilas Bank and the managing director of Lakshmi Vilas Bank, he could not purchase shares directly in excess of certain limits, which are because of the listing requirements of the stock exchange. So he cannot make that cross that threshold. Then he has to make a public offer. To avoid all that, through his companies, both Pranava City, who is the plaintiff before your lordship, and Pranava Electronic, funds were given to Sagittarian. Now, Sagittarian had to show repayment of the funds to Pranava Electronic, and that is why this mechanism was devised, that Pranava City will give me money, I will give money to Sagittarian, Sagittarian will repay to its associate company. So the funds never stayed with me. Now, this has been disputed by them. So when I filed the affidavit in opposition, my lord, I did not have the bank account statements of all these entities. And so they have, my lord, bald there in the affidavit in reply, your lordship will find is a bald denial of my case. It's absolute categorical denial that there's nothing of this sort. I had also in my affidavit in opposition annexed one document which was prior to the institution of the suit. That was a criminal complaint. Criminal complaint, same allegations, but giving it the criminal flavor of cheating, and said, this is cheating, you have taken loan from me, you have not repaid that loan. That criminal complaint, my lord, was the FIR was registered, but ultimately a final true report was filed discharging me from any criminal liability, saying that this is a circular transaction. Upon investigation, the police reported that this was a circular transaction. So that is the only document which I had at that stage in the opposition to show circular transaction. And I also showed my bank account statement, which would show that monies which I received from them promptly went to Sagittarian without any time lag, in exact amounts. So in the reply, they squarely denied this, says no, there is no such transaction, flat denial. Now, my lord, I filed a supplementary affidavit where I disclosed not only my bank statements already there, but the plaintiff's bank statement, as well as, my lord, the bank statement of Sagittarian, which would show the complete transaction. They used, my lord, a supplementary rejoinder where they did not disclose anything to counter the specific documents which I had. Because your lordship bears in mind, Pranava's Electronic is also their entity under the same control and management. They could have easily shown Pranava Electronics bank statement to, my lord, debunk my entire story that no, where's the circular transaction? It ends with Sagittarian. What you did with your money, I am not concerned. But see, Sagittarian never paid anything to Pranava Electronic, but no such attempt made. So that is, my lord, and if your lordship would have the supplementary affidavit once, paragraph 5, please, my lord, once.
Of GA?
Paragraph 5, I'm sorry.
GA1.
GA1.
Yes.
Your Lordship will see in paragraph 5, I have shown, my lord, this entire circular transaction, how the monies have come and how the monies have gone back from the plaintiff to the defendant. And this, your Lordship has made note also. I don't want to take your, I made one mistake, my lord. I showed your lord, with this, I have disclosed the bank account statement of Pranava Electronic, which is the sister concern of the plaintiff. Kindly see page 6, please, my lord. And the entries also, your Lordship had marked on the last occasion. So I'm not troubling your Lordship again. Page 6 is the bank account statement of the sister concern, Pranava Electronics, his sister concern. And my lord, page 10 is the bank account statement of Sagittarian Credit.
Yes.
Which is, my lord, the middleman, the broker who was doing this transaction, my lord, circular transaction.
Correct.
My lord, plaintiff does not, and the bank statement which the plaintiff has disclosed, my lord, in his petition also reflect these entries where Pranava Electronic has returned monies. Kindly see, my lord. And the plaintiff's petition once. Kindly have the petition once, yes. Page 33 onwards is the plaintiff's bank statement.
Yes.
Kindly see. Plaintiff also, my lord, receives monies from K.R. Pradeep. Kindly see, my lord, page 33.
Yes.
About first, second, third, fourth entry.
Pradeep. Yes.
Yes. Now, there is no explanation from the plaintiff, my lord, of its involvement with K.R. Pradeep on Pranava City. This K.R. Pradeep, my lord, is the promoter. As why is he is the promoter of all these entities. Lakshmi Vilas Bank, Pranava City and Pranava Electronic.
Yes.
So, my lord, his involvement is clear and that he is funding, in fact, the plaintiff to advance funds is clear from this, my lord. And the funds which the plaintiff gives to me, my lord, are at the bottom of that page, which have all gone to Sagittarian and then through Sagittarian to Pranava Electronics, which is also K.R. Pradeep's company. So it starts from, my lord, the plaintiff's promoter and ends with another entity promoted by the plaintiff. Now, my lord, print out one document, if you look, and this they would also have the first final report which had been published, which had been made by the police authorities on an investigation at their instance. They had filed a narazi. An objection was filed, which was allowed. Second report was called for. Second report, my lord, has now come after I had filed my supplementary. I've got a certified copy. Police reiterates the same, that this is a circular transaction. May I just give your lordship a copy? This is on their complaint. They would be having a copy of this, my lord. It's fairly recent. If your lordship turns to the next page, your lordship will find the date, 12th August 2025. Now, my lord, your lordship kindly sees name of the complainant.
Page?
Page 2, please, my lord, of the compilation which I handed over. Kindly see page 2, serial 9. Lordship will find the date, 12th August, second FRT of 12th August 25 on the top left-hand corner as well as right-hand side. Then kindly see serial 9, please, my lord. Name of the complainant, Harish HR, the authorized representative of Pranava City Complex, my lord, who is the plaintiff before your lordship. Then, my lord, kindly turn over to the next page. Under serial 16 are the facts of the case.
Yes.
Harish HR, the authorized representative of Pranava City Complex, having office at so-and-so, submitted a written complaint against the directors of 5 companies, namely Monet Securities, I am Gyan Traders, my lord, number 2. Yes. Flex Trade, RAS Associates, Subla for not paying 4 crores, 3 crores respectively during the year 2018 through RTGS from the head office in Bangalore to earn interest. The lender companies have furnished the TDS in their balance sheet that they have received loans, but they have neither furnished the installment of interest nor the principal amount of loan over the complainant. So-and-so has been filed. My lord, from the cause list, my lord, it appears that 5 suits have been filed by them. 1 is being prosecuted, I am being prosecuted, but all 5 suits are there before your lordship. In respect of all these 5 companies, suits have been filed before your lordship, my lord, or in this court at least. Then, my lord, is the detail of investigation. I'm not troubling your lordship with the investigation, all the documents they've collected. Then kindly come to the next, where it is written 882 at the top right hand, please, my lord. 882, your lordship finds.
Yes.
Kindly come to the 4th or 5th paragraph, my lord. In course of further investigation.
Page number?
Page 882, my lord. On the top right hand, there's a small numbering.
Yes, yes, yes.
Then kindly come to the paragraph in the middle, my lord. In case of further investigation.
Yes.
In course of further investigation of this case, from the statements of complainant, witnesses, directors of accused companies, and from other evidence collected, it is revealed that the complainant K.R. Pradeep is the managing director of both Pranava City Complex and Pranava Electronics. And he was also managing director and promoter of Lakshmi Vilas Bank. In 2014, Pradeep wanted to buy a major portion of shares of Lakshmi Vilas Bank, but as per rules as an MD, he had a limit to buy the shares of his own company, Lakshmi Vilas Bank. Consequently, he met with a mediator, Raju Kumar Patni, in February 2014, and Pradeep requested Patni to arrange for the purchase of Lakshmi Vilas Bank shares through margin funding. Patni arranged for two companies, Sagittarian Credit Capital Private Limited, to provide the margin, and Stupenders Traders Private Limited to buy the shares. Then, my lord, all these transactions between them are noticed. Kindly come to the last paragraph there, my lord. Sagittarian Credit has received 24 crores from Pradeep's company in 2014. However, in 2018, some issues of income tax cropped up, as Sagittarian Credit company's net worth was quite low and it could not take a loan of 24 crores. Accordingly, Pradeep requested Patni to transfer an amount of rupees 11.5 crores from Sagittarian to 5 different companies. Patni accordingly arranged for transferring 11.5 crores from Sagittarian to 5 different companies, namely Monet, Gyan, etc. This transfer shift of money to the 5 companies was done to resolve the issue of income tax due to low net worth of Sagittarian Credit, but the same was shown as loan to those 5 companies as per Pradeep's request. Then, my lord, all these narration is further continuing. Kindly come to the next page, my lord, very important. Though my client has not been able to get this email, it seems police have retrieved this email from Pradeep. Kindly see 883, second line. Later realizing his fault. Your lordship has that?
83.
883.
Yes.
883, yes, my lord. 883, second line. Later realizing his fault. Your lordship has that?
Second line.
Second line, please, my lord. Later.
Yes, later.
Later realizing his fault, K.R. Pradeep's companies made an agreement and sent the draft copy of those agreements through emails to the accused companies. I have not been able to retrieve this, my lord, but it seems police has recovered this from the plaintiff and K.R. Pradeep. But there is no signature of any party in the said loan agreement. So legally, it cannot be accepted as a loan agreement. In the agreement, it is not mentioned the terms and conditions of repayment. In our plaint, my lord, no loan agreement is disclosed. What is said is there's a loan agreement between a company in Bangalore with a company in Calcutta. How the loan agreement is entered into, no prior correspondence, no documentary evidence of a loan agreement. And here the police seem to have recovered, my lord, an email and the draft copy of the agreements.
Yes.
Now, my lord, the bank statements have been, police has gone through the bank statements.
Yes.
From the bank statements collected, the transactions can be tabulated as follows. Payment to Pranava Electronics, my lord, which I said is the main company. Payment to Pranava Electronics from Sagittarian Credit is notice amounting to 11.5 crores. Then kindly see payment from Pranava City to all these 5 companies, refund of 11.5 crores. Then kindly turn over, my lord, where your lordship will find how these monies have. Kindly see serial 2 at page 884. Gyan Traders Private Limited received loan from Pranava City Complex on 12th March, rupees 2 crores, and on 13th March, 1 crore, total rupees 3 crores. Gyan Traders Limited transferred to Sagittarian Credit Private Limited on 22nd March, 3.15 crores. This is the entries which I have also referred to, my lord, in my petition. I'm sorry, my opposition. Then all the bank statements police has gone through. Then your lordship kindly sees 885 top. There is neither any loan agreement nor any MOU between the complainant's company and the accused companies. Moreover, no security deposit was taken on granting this loan. but the loan was sanctioned only on the words of Raju Patni. The complainant failed to show any resolution, kindly see, the complainant failed to show any resolution of the board of directors of Pranava Electronics or Pranava, which would city, that is the plaintiff, which could reflect the unified decision of the directors to provide loan to the accused companies. Company has to act on the basis of board resolution. This is not a money lending NBFC. He doesn't have an NBFC license. No board resolution is disclosed before your lordship also. So no loan agreement, no board resolution. The 5 accused companies had no previous business relation with the companies of the complainant, and they do not even know the complainant K.R. Pradeep. In spite of that, money was transferred on the pretext of loan to those companies only on the basis of verbal communication. Raju Kumar Patni advised the complainant to transfer money to these 5 companies. Actually, this was done to tackle the issue of Sagittarian company's low net worth, but the transfer was attempted to be shown as loan to these companies. The accused companies never approached, kindly see, accused companies never approached or sought any loan from the complainant company, yet huge amounts were transferred to those 5 companies by the complainant's company. Well, here also in the plaint, they've not shown even one email correspondence between the parties requesting them to grant a loan. And then, my lord, this transaction, page 886, the court, the police have also come to a conclusion that this is not a criminal offense. If there is a transaction, it is a civil transaction, and criminal offense, no prima facie charge could be established. Last but one paragraph. In course of investigation, no allegation of cheating, forgery, or any criminal intent in repaying back the loans could be substantiated, as there is evidence of absence of conclusive proof of fraudulent intent, absence of forensic evidence of forgery, the TDS payment showing acknowledgement of debt, and keeping in mind the judicial caution against criminalizing civil disputes, no prima facie charge could be established. The matter is civil in nature. My lord, I am relying on this only to show that there is a prior attempt was made on the self-same transaction, giving it the allegation of cheating. That has failed, and the investigation showed by the police also shows the defense. Today, my lord, on a judgment on admission application, the case has to be a clear categorical admission, my lord. In this case, my lord, there is no such admission, save and except, my lord, the deposit of TDS, which I have said was given to give the character of a loan transaction to the parties.
Yes.
Those are my respects.
Thank you.
But with all due respect to my learned friend Millard, he has not answered the only question that is required in a suit for money lent and advanced. My learned friend has shown various transactions to allege and give a picture before your lordship that look, the loan that I have taken was part of a circuitous transaction. Could be, for argument's sake, at a judgment on admission stage, without my lord going into trial, I'd say accept it as correct. Because, my lord, what my learned friend is trying to do, my lord, he is trying to create an aura that as if the court cannot decide the question of loan without going into the question of evidence. This is all he's trying to do. So, my lord, he has come up with the best evidence, supplementary affidavit, and he's given his best shot. I am saying accept everything to be correct. Even then, it doesn't answer the question which is required in an order, in a judgment on admission. I have come up before your lordship saying that, look, I have given loan to the defendant, and the defendant has acknowledged receipt of this money on account of loan. He has paid TDS. He has given a balance confirmation. These are the 3 documents I have in my possession. Now, Millard, if I may ask myself this question, my cause of action is dependent on these 3 documents.
Yes.
These 3 documents will, Millard, without any doubt, disclose the fact that yes, a loan has taken place, because there is an acknowledgement of debt along with interest. Had it been a circuitous transaction, then there would not have been any question of interest payable by him. Now, faced with these 3 documents, the first stand which my learned friend takes in his affidavit in opposition that yes, it is a loan. And it is to be shown as a loan, but it was not actually a loan.
Now, my lord, if I may ask myself this question, that if you admit in your books that it is a loan, if you admit in your pleadings that yes, it was shown to be a loan, are you not bound by those statements that you have made? Question is, he files a supplementary affidavit trying to show that X is a company, Sagittarian is a company, who has given the money to the plaintiff. The plaintiff has passed on money through another subsidiary company to the defendant. So that is the way he received the loan. Now, my lord, in a suit for money lent and advanced, suppose I am the plaintiff, I borrow money from my learned junior and give it to him. Is it my learned friend's defense in a suit for money that, look, the money which you have given to me is not your money? That is exactly what he is trying to do. He is trying to say.
He is telling that the amount with the circulation, it has been paid.
So therefore, I'm coming one by one. So therefore, his first contention was, kindly look at the chart. He says, if you look at the chart, you will find that money was routed through a circuitous transaction.
Correct.
Why? Because somebody else has paid money to the plaintiff.
Correct.
Who is that somebody? That somebody is gentleman who is not connected with the plaintiff, and he is Mr. Raju or whoever it is. He is in control of a company called Sagittarian. So it is not the plaintiff who has given me the money. Money has come to the plaintiff from Sagittarian. Accept it as correct. Thereafter, through a sister concern, Pranova Electronics to Pranova City, it has come to me. TC admits. Now, thereafter, he says, from here, the money again goes back to Sagittarian. Now, my lord, there is one more gap required. Between Sagittarian and Pranova, if I have given the loan to him, and if his argument is correct, the money has to come back to me. If that chain is not there, my lord, and he is not saying that the money has come back to me. So if that is so, my lord, if he has been party to a transaction, my lord, and he is unable to show that the money has gone back to the plaintiff, then it is for him to sue the person that, look, I have sued, I have received the money. You know it is a transaction. The plaintiff is the claiming the money from me. You indemnify me, you pay me back, because I am liable and responsible to the plaintiff. Now, so therefore, a circuitous transaction would only mean that money going from me to the defendant, and through somebody, it is coming back to the plaintiff.
Correct.
That is not what is coming out. Kindly, my lord, take the supplementary affidavit once. He's been crying hoarse, trying to create, my lord, this smoke, that as if. Kindly, my lord, take the supplementary affidavit.
Yes.
Kindly remember, these are all individual limited companies.
Yes.
Sagittarian goes to Pranova Electronics, not the plaintiff. I'm sorry, at page 3, paragraph 5.
Yes.
Accept this to be correct. Sagittarian plays to Pranova Electronics 2 crores and 1 crore, 3 crore.
Yes.
No problem. Pranova Electronics is not the plaintiff. Pranova Limited to KR Pradeep.
1 crore.
KR Pradeep, thereafter, my lord, from 12th of March, KR Pradeep to the plaintiff.
Correct.
First 3 transactions, 3 crores.
Yes.
Then from plaintiff to defendant. Turn over the page. It ends with defendant to Sagittarian. It doesn't come back to the plaintiff.
So what about that earlier transaction?
Yes. Sagittarian is a person,
Yes.
according to him,
Hmm.
gives money to Pranova,
Correct.
which is not the plaintiff. Pranova gives it to KR Pradeep.
Correct.
Our suit starts, my lord, from from plaintiff to defendant. So till 12th of March, where it is written KR Pradeep to plaintiff, I just submitted, my lord, from where I get the money is not the defendant's concern. I may have borrowed the money. May have stolen the money. But I have given to you, which you have indicated in your books as a loan.
Yes.
You have given me a balance confirmation. You have filed TDS and you have shown payment of interest. And you also say that I have paid interest. So once it starts from plaintiff to defendant, to be a circuitous transaction, all these are plaintiff to defendant, he admits, then from defendant to Sagittarian. And the cycle stops there. So he cannot plead circuitous transaction. A circuitous transaction means a transaction, my lord, which will, what can he come and say? That look, you the plaintiff, you have given me money, and at your instance, I have given it back to you.
So with regard to now the first,
my lord,
Sagittarian to Pranava,
yes,
2 crore.
This is not the plaintiff.
Whatever it may be, but here
Accept it. At Pranava Electronics, KR Pradeep, plaintiff are one person. Accept it. So all it will do, it will cut short the entire transaction. So Sagittarian gives money to the plaintiff.
Correct.
If Sagittarian, there's nobody's case that Sagittarian is the plaintiff.
No.
Nobody's case. So Sagittarian is a third party in this transaction. Plaintiff to defendant, no problem. From defendant to Sagittarian.
So this 12th March 2000 plaintiff to defendant.
Yes.
Till the 13th March 2018.
All these are loans.
So these are the total 3 crore 15.
Yes.
These are the total. These are the total 3 crore 15. If this 3 crore 15 and now come to the 1st of 12th of March 2018.
Money 3 crore 50.
Correct. So 3 crore 15. So it has come to the Pranava Electronics, not to the Pranava City.
Millard, accept it. I am saying, Millard, Millard, I am responsible for what I am submitting. That accept Pranava Electronics, accept KR Pradeep, and accept the plaintiff as one person.
Correct.
So whatever is, so Sagittarian, plaintiff, defendant, Sagittarian. You just cut short. My learned friend is defending a case of money lent and advanced. So he has to show that money has gone back to you. The loan that is reflected in my account has gone back to Pranava. If I have borrowed money from, say, my junior, Mr. Banerjee, I have borrowed money from Mr. Banerjee 10 rupees. It is shown that I have borrowed money. Sagittarian to plaintiff. Plaintiff to Mr. Katie's client. And Mr. Katie's client to Mr. Banerjee's client. Now, the loan that is between you and me, that is the cause of action in this suit. Now, my learned friend will have to justify in the trial that the money that Mr. Katie has paid to Mr. Banerjee was at my instance.
Correct.
That is not the case.
Correct. So that's why if it is there, then how this 12
So therefore, if it is, if money has gone back to Sagittarian to Mr. Banerjee, and Mr. Banerjee is not a party to the suit, and I am calling upon him, then obviously when I call upon him, then Mr. Katie will have to call upon Mr. To indemnify him. So that would not be an answer to my demand. That is a transaction between Mr. Katie's.
So that is the matter of trial. So how
Millard, obvious, Millard, as I tell your lordship, Millard, is it open to if I pay money to Mr. Katie's client, Mr. Katie's client cannot say that at your instance I paid money to somebody unless he can show that there were instructions in writing that payment by Mr. Katie to Mr. Banerjee will discharge him from the loan to me. That is not the case. That is not the case. He is not saying ever, in spite of giving all best opportunities, that look, you the plaintiff had asked me to pay to Mr. Banerjee, and by paying off to Mr. Banerjee, I am discharged of the loan. He is not saying that.
So what is your answer? This amount has not been received by you.
No, that's an admitted fact.
Where is the statement on that?
My lord, his own chart will show that. I am giving him the best possible.
No, that's correct. That's why he has made out a case that is this Pranava City Complex Private Limited and the Pranava Electronics Private Limited are the sister concerns.
Accepted, correct.
Are the sister concerns. So the Mr. Thakkar has made out a case, yet it is a sister concern, though he received the amount from you, but it has been.
So I have given it back to a sister concern. Does the chart say so? That he has given it to a sister concern? Because the sister concern are Pranava Electronics, Pranava
Private limited.
Complex and KR Pradeep.
Hmm.
He is given it to Sagittarian.
Sagittarian, then Sagittarian given to Pranava.
No.
As per the serial number 1, 2, and 3.
Millard, as I told your lordship, Millard, I borrow money from Sagittarian and I give it to him. He shows it as a loan. Very well. And thereafter he pays it back to Mr. Banerjee through me, not through me, without me.
Back.
So if his argument would have been correct, there would have been one more entry that Sagittarian to Pranava. That one entry is missing. This is the crux of the matter. Whatever evidence your lordship leads, this is the best evidence he has come forward. Even if your lordship accepts that he still has a chance to show, he cannot show because his documentary evidence ends with the fact that money has not gone back to the plaintiff.
Okay.
Number one. Bolo. Now, Millard, I have given a reply to this supplementary affidavit. Kindly, Millard, come to paragraph 5. That it has not come back to me. Millard, your lordship said where have I stated that?
Yes.
Page 5, paragraph 6.
Of the affidavit?
Of it would be, Millard, a supplementary affidavit filed on behalf of the respondent to their supplementary
affidavit in opposition to the supplementary.
Reply to the supplementary affidavit.
TV Anand.
Anand
TV.
Yes, TV. Will it kindly take from paragraph 3?
Paragraph
3. Page 3, paragraph Roman 2. Sorry.
Yes.
The petitioner had lent a sum of rupees 3 crores to the respondent, which has been confirmed through reconciliation of accounts and is an undisputed fact. This he has admitted in his opposition. There are TDS certificates on record to endorse the fact that loan which was granted to the respondent bore interest at 9%. The documents bear the signature of authorized representatives of the respondent, also bears the stamp so and so. Thereupon, the petitioner entitled to relief or judgment. The respondent attempted to explain why the admission made in various documents have introduced a concocted version of a real transaction in its affidavit in opposition, and the said supplement none of his respondent can prove in the suit nor are allegations germane to the issues in the suit. I even go forward and say that accept it to be correct for my argument. The allegations in GA1 are sham transaction. Real transaction was a circular dealing with the plaintiff, defendant, Pranava, such and such, which was organized by K.R. Raju and is not a beneficiary of the sum, and the defendant not a beneficiary transfer a sum of rupees 3 crore transferred by the plaintiff to it was only a conduit for routing the fund, are wholly irrelevant, especially in the presence of documents which speak otherwise. Such allegations are admissible. The chart table purported on the based on the purported copies of the bank statements of Pranava and Sagittarian alleged by the respondent does not show involvement of any circular deal or routing of funds. Without relying on the alleged chart or the purported copies of the, I say that Pranava Electronics, Sagittarian, KR Pradeep and the plaintiff and the defendant are separate entities and are legally free to make independent transactions. The aggregate amount of 3 crore which was advanced by the plaintiff to the defendant was also an independent intercorporate loan received by the respondent under the terms to repay the same with interest at the rate of 9% per annum. Why will he repay if it is a circuitous transaction? Not only did the respondent sign confirmation of accounts after the reconciliation admitting such fact, but has also admittedly paid interest at the rate of 9% per annum and had deducted statutory tax at source given the plaintiff to the defendant. Therefore, these allegations are wholly irrelevant, especially in the presence of documents which speak otherwise. Thus, allegations are inadmissible in evidence. The contents of the copies of the bank statement cannot be alleged to be true and authentic by the deponent. But here, my lord, I also say accept it as correct. And even if your lordship accepts is that correct, your lordship will find it does not disclose a circular transaction. This is, my lord, 1.
Now, my lord, my learned friend had shown a catena of judgments on admission has to be clear and unequivocal. Admission can be from documents, admission can be from pleadings. Now, my lord, documents I had shown that 3 documents I had shown. One is money going from me to him, which he admits. Secondly, he admits paying tax deduct TDS because in his books it is shown as a loan. And number 3, he has a balance confirmation at page 37, which shows that it was a loan transaction. Now, Millard, so far as these 3 documents are concerned, which is all, Millard, the evidence that I have in a suit for money lent and advanced. On the basis of these 3 documents, I can understand any defense taken by my learned friend that this is forged, this is not concocted, coercion, undue influence. He goes on to say that yes, it was a loan transaction. So, Millard, what more, if I may ask myself this question, what more evidence is required when that categorical statement in the affidavit in opposition clearly says that yes, it was a loan? But he goes on to say that there is something more. Now, even if there is something more, would it be a defense to your case that your book shows it's a loan? My book shows it's a loan, and I am unable to show that I have repaid money to the plaintiff. So, Millard, whatever evidence or slightest bit of evidence that can come over here, Millard, is whether at the instance of Sagittarian has again repaid the money to me. He doesn't say that. So, Millard, as a plaintiff, if I may ask myself this question, whatever transactions he shows, will it be open for the court to connect the dots to find that no, the plaintiff, you have got the money? Because the plaintiff is not saying, defendant is not saying that. Now, this is, Millard, so far as my judgment on admission is concerned. Oh.
Because he has not admitted it is a loan amount.
Yes,
It is admitted that
unconditional.
He admitted that the circular transaction, circular
Millard,
page.
unconditional, I'll show you, Lordship. Millard, kindly take his affidavit in opposition once. Millard, it's already 1:15, Millard. I'm ingressing into your Lordship's time. I'll come back tomorrow. Tomorrow it's also fixed.
Tomorrow fixed. Learned counsel for the defendant has concluded his argument. Counsel for the plaintiff has argued the matter at length in reply, but due to paucity of time, hearing could not be completed. It is found that the matter is already fixed tomorrow at 12:30 p.m. Let the matter appear tomorrow at 12:30 p.m.
Your Lordship, the plaintiff has concluded, the defendant has.
Defendant concluded.
Lordship, item number 17, Lordship.
Lunch time.
the matter need be withdrawn. I've come with the written instruction also to be kept in the record.
Lordship, I appear on behalf of the defendant number 2.
Your objection?
Well, at the time of
Where is the return?
it is unfortunate.
You will be at risk.
Yes, that's why my lord. I boasted. Or the instruction.
Though the matter is fixed today, especially fixed today for witness action at 2 p.m. But the learned counsel for the plaintiff submits that
On instruction, on written instruction.
he has got the written instruction from the plaintiff.
From the plaintiff, my lord.
From the plaintiff to withdraw the instant suit against the defendant. Please stop. Counsel for the plaintiff has handed over the written instructions dated 1st September 2025, wherein the plaintiff has requested the advocate of the plaintiff to withdraw the case filed against the defendant. In view of the submission made by the counsel for the plaintiff and as per the written instruction dated 1st September 2025, CS Com 280 of 2024 within bracket old CS 126 of 2021, Mickey Metals Limited versus Putul Ghosh and another is dismissed as withdrawn. Interim order, if any, stand vacated. Consequently, all connected application, if any, also disposed.
And the written instruction be kept on record.
Instruction be kept with the record.
Grateful, my lord.
Yes, call.
I appear for the judgment debtors number 6 and 7, my lord. They are surrendering before this honorable court, my lord. There was a direction for filing affidavit of asset, man. I'm filing asset on behalf of the judgment debtor number 6 and 7.
Who has been brought under arrest? Nobody is arrested. They are surrendering. Who is surrendering?
Judgment debtor number 6 and 7, my lord.
What is the name? Firoz Akhtar?
Yes, my
Firoz
lord.
Akhtar?
Yes, sir.
And
Firoz
Mr. S.
Akhtar
Roy.
Boiddo.
Huh?
Firoz Akhtar Boiddo.
And S. Roy. Judgment debtor number 7. 6 and 7 are surrendering, man.
6 and 7. Yes. Who is for the plaintiff?
My lord, I appear for the decree holder, my lord.
Hmm.
My lord, if they're surrendering, my lord, I cannot stand in the way.
Hmm.
But my lord, the affidavit of assets need to come in.
Have you filed?
Filing. Today I'm filing this affidavit. My lord, in course of the day, I will serve the copy to the plaintiff, my lord.
Show the copy. You're not gone through my direction with regard to the how the affidavit is to be affirmed. Where is the statement that you're not this statement is true and correct and you're not suppressed any fact? Where is that statement here?
Affidavit has been, my lord, affirmed as per order 21 rule.
Correct. Affidavit, but where is the statement that you're not suppressed any material fact?
Asif, I have
In my judgment, I already stated this is to be incorporated. You are not suppressed any material fact, and this is statement are correct.
Lordship, at paragraph 10, Lordship, I have stated that the statements made in the foregoing paragraphs are
True to my knowledge.
Yes. And
true and correct, where is that?
Fine.
True to your knowledge, but true and correct, where is that?
Yes,
and you are not suppressed any further material fact. You might be having some other company. Okay, both have filed.
Both.
Recorded note. He warrant వచ్చి Defendant number, judgment debtor number 6 and 7, namely Firoz Akhtar Badya, and Sudarshan Roy, alias S. Roy, have surrendered before this court against the warrant issued by this court by an order dated 18th August 2025. Both the judgment debtors have filed affidavit of assets. Let the same be kept with the record. The judgment debtors are directed to serve the copy of the affidavit of assets to the learned counsel appearing for the decree holder by
Course of the day,
in course of the day. Full stop. As the judgment debtors have surrendered voluntarily before this court and have filed the affidavit of service, affidavit of assets, taking into consideration the judgment debtors have been released on personal bond with the direction to appear before this court as and when required by this court. What is the date fix? Let the matter appear on 9th of September 2025.
Great.
Full stop. As the judgment debtors have surrendered before this judgment debtor number 6 and 7 and voluntary surrender before this court, accordingly warrant issued against the judgment debtor number 6 and 7 is recalled.
Great.
Grateful. Item number 11.
Oh, अच्छा.
Lord, before Lord, everybody starts, Lord, I'll file my report. In terms of the last order, Lord, I have visited the premises. Lord, the only thing, Lord, is that this property which I have been directed to take physical possession, there is one padlock which is kept by me, and Lord, and your Lordship may kindly sees the very first photo in the report. Your Lordship may kindly sees there is a shutter lock. Has my Lord been able to see that key blank? Lord, that is by someone whom I don't know, Lord. That has been put somewhere. And your Lordship may kindly turns to the third photograph. Your Lordship may kindly sees where I am standing, Lord. It's not paginated. The third photograph. Your Lordship may kindly sees I am pointing to a particular space, my Lord. There, my Lord, 3 times I have pasted notice, and Lord, 3 times someone, Lord, has withdrawn this notice. Though, my Lord, I have not mentioned this in my report, but on the previous visit when I visited, my Lord, the director of the defendant company, she, my Lord, had agreed that she is removing these notices because of the bank issue, that they are proceeding with the bank. This is, my Lord, these are my Lord, I could not take physical possession because of this impediment, my Lord. I'm serving the copy of the report to both the sides. And the previous reports, my Lord, since he was not appearing, it's with the records of this honorable court, my Lord. Director. Has been revived.
Yes. Where is the another lock?
My lord, that is the lock, my lord. Yes, the key which they have
Earlier
put
it
and
was
which they have-
open.
No, my Lord, earlier it was also padlock, my Lord. There was an earlier lock at the left hand side, which is not there anymore.
My lord, the wife had agreed to open it.
This one.
Yes.
Side by side.
Side.
That was opened.
Yes, my Lord, that, your Lordship, I'll just kindly seize the second page. My Lord, where I'm sitting, my Lord. My Lord, this lock has been put by me on the left hand side. There was a lock which was not there on the last visit, but it was there on the visit before. This was removed. I don't know who has put it and who has removed it. And my Lord, the lock which is inside the shutter, someone else has put it.
The
which
shutter
was
lock is still there.
No, when you put the lock,
yes,
at that time shutter was open or
shutter was locked, my Lord, already
it was
locked.
under lock.
It was already on. It was, my Lord, always
No,
locked.
locked or no? It was shut down, but it is
shut
locked or not?
Locked.
It was locked.
Locked.
Locked by a padlock or
Locked by, my Lord, that inside locker.
inside lock.
Inside lock.
Okay. So what? Where is the second lock? You are telling that.
Lord, on the left hand side where I'm sitting, my Lord, that was there earlier. Now it's not there.
No, it is not.
Now
there.
it's not there.
So morning you're telling that there is a
No,
lock.
I was, my lord, the shuttle lock, my lord, I was.
Shuttle lock already there.
Yes, shuttle lock is, my lord, that needs to be broken open.
That is already there. That is, yes.
My instruction is this, that we have not put any padlock.
Why you remove the notice? Why you
Not,
remove
not
the
just here in
Why you remove the notice?
not just here in the room also, the residential house where they're residing, there also they have removed it.
Why you removing
The other
where is the defendant?
The defendant is not in Kolkata, my lord, but defendant is willing and ready to come before my lord and give it on deposition. In fact, on affidavit that they have not taken any steps.
And regarding removal of notice?
Sir, I cannot find from the report itself where somebody has stated regarding my lord. My lord finds
3, 4, and 5. Read the 3, 4, and 5. Especially 4 and 5.
has been removed.
Not once, twice.
in the earlier report also it's mentioned.
Yes, it is there. In the earlier report, there is a first report. There is a notice pasted photograph is also there. Then,
my lord, if the defendant has removed the padlock, my lord will direct to file an affidavit. He will disclose it, and if they have removed and the reason for why they have removed it, my lord, they shall come before my lord.
My lord, kindly takes the report of the learned receiver, my lord. I need not, my lord, go anywhere. Kindly come to the report of the learned receiver, which was filed, my lord, which is dated, my lord, 9th of June 2025, the previous report. Kindly comes to paragraph 14.
9th June.
Yes. They need not file an affidavit. It's an admitted position now. Paragraph 14. I again found that the earlier notice pasted by me was removed. I had provided a copy of the order to the directors and inquired who had removed the earlier notice. The directors answered that the same were removed by them. But it is pertinent to mention that no such information was given to me before removal of the notice. It's an admitted position. You're clearly in contempt.
My lord, in fact, if that is the reason, so I am not aware of the first report. If I can get a copy of that, I just request my
second report. Yes, this is the second report, not the first report.
This is the third report.
If I get a copy of the two other reports, my lord, and also I will.
But the earlier reports are with the records of the court, my lord, because they were not appearing. So that is why.
Kindly pass the direction so that I can, the defendant can come up with an affidavit, an explanation as to why such steps were taken.
Not steps. Kindly see the 14, paragraph 14.
My lord,
Copy है. It's an attachment. 9th June. Another उससे पहले 4th April report. ये इसका second copy. The 4th April, you're given the advance copy, no?
No, Lord, I've given it to the plaintiff. They were not being represented before.
Since today we are before my lord, then my lord gives us opportunity to come with an affidavit.
My lord, each and every time my advocate on record has given them a notice of the hearing. They don't come. Only when the attachment has been taken, enforced, they come before your lordship.
Cannot today, my lord, submit regarding the
affidavit of service before your lordship.
My lord, whatever there is, my lord, there is, my lord. I cannot shy away from that. In fact, the defendant as well. But still, the defendant is.
You have a copy of the reports?
Yes, no, I have the soft copies.
Give the copy.
I will give it to my learned friend.
Thank you.
Well, with regard to the surfacey, My lord, I have caused a little search. My lord, what has been directed to be attached and sold is a BT road property, not this property. My lord,
Whatever it is,
that's not.
let they come. I will see to that.
I wish they got to this property.
Instead of removing, why they will not come before this court and file an affidavit? This is the situation. You are more not about the court. Your clients are not about the court. Then, if the special officer has done some work and you have removed, that means you have removed the notice of the court only, not the special officer in person. Then
they should come up with an affidavit
and inform your client to he has to face the consequences.
That is
and which is the nearest place?
Park Street. Hey, my lord, Hay Street.
No.
Oh,
Correctional home, where is that? Tell your client.
The presidency.
Had to.
gives an opportunity, last opportunity.
That's why I am giving opportunity, but keeping in mind what explanation will come, but it is admitted, your client has admitted that they have removed. And this court cannot overlook the report of the special officer.
My lord, let me get a copy. I'll take instruction, and my lord, I'll.
Learned counsel for the plaintiff, my special officer, and the learned counsel for the judgment, and the defendant is present. Full list of counsel for the special officer has filed the report. Wherein it is mentioned that the special officer has pasted the notice in the premises, but the same was removed without any notice or intimation to the special officer. In the report dated 19th June 2025, in paragraph 14, the special officer has categorically stated that the earlier notice pasted by the special officer was removed, and the special officer provided the copy of the order dated 16th April 2025 to the directors of the defendant company and inquired who had removed the earlier notice of symbolic possession, the directors answered that the same was removed by them, but the directors are not informed the special officer before removal of the said notice, which was pasted by the special officer in terms of the order passed by this. This court finds that the defendants, instead of appearing before this court and having the knowledge that this court has passed an order for symbolic possession, according the special officer has pasted the notice in the premises, taking the symbolic possession of the premises in question, but avoiding the order passed by this court and avoiding the order passed by this court, have removed the notice pasted by the special officer without any leave from this court. In view of the above, this court finds that before proceeding further against the defendants, one opportunity should be given to explain as to why the defendants, without the leave of this court, have removed the possession notice pasted by the special officer in the premises of the defendant. Let the reply be filed. Let the so-cause be filed by
fortnight.
By 2 weeks. After serving the copy to the learned counsel for the plaintiff, the plaintiff has the liberty to deal with the affidavit, if any, filed by the reply to the so-cause notice, if any, filed by the defendants within a week. List the matter on 21st of August 2025. September 2025.
21st is a Sunday.
22nd. आज एक है ना 2 हफ्ता 15 हो जाएगा.
One more.
In the meantime,
I am giving 10 days. 10 days time. 2 weeks, not 10 days.
My lord, the defendant is on substitution, so my lord, if for the affirmation.
No.
by the 15th, I believe my defendant will be able
Maybe come. I am giving 10 days. You have to come. If you're not able to file, you not file. You have committed the contempt of the order. Within 10 days, reply within a week. List the matter on 22nd.
My lord, in the meantime, I'm one more indulgence, my lord. Since it's new advocate on record, yet to file Vakalatnama competence, leave may be granted.
Leave is granted to the learner advocate on learner advocate to file Vakalatnama on behalf of the defendants within a week from date.
Well, in the meantime, my lord, the inventory, my lord, with regard to FNG.
Let they come. Let they come.
Great.
Well, then in that event, my lord, your lordship would kindly give them that to in their show cause, not only the removal, but also, my lord, the who has put the keys, who has locked the shutter.
The defendants also explain why the defendants are not allowed, not open the internal key of the
shutter lock,
and allowed the special officer to make inventory of the shop room.
No, it's an office.
Of the office.
Well, it will be better, my lord, the premises number if your lordship
Of the
does give.
premises number.
As mentioned in the last order, my lord.
My lord,
Yeah, the
Last order, the details is there.
Order. Of the premises number.
My lord, Merlin Warden, Lake View, 104, Bidhannagar Road, first floor, block 1, unit F&G, Kolkata 67.
Warden, Lake View,
Great. Yeah. Borough flats. Great.
Yes, call the man.
I'm for the plaintiff lordship. This is
For the defendant, your lordship.
Yes.
lordship. The dispute in this suit has been amicably resolved by the parties. The dispute in the suit has been resolved by the parties amicably, and mutual settlement agreement is entered between the parties dated 22nd May 2025. And subsequently, we, in accordance with the terms, we have filed one joint compromise petition with a pray to
where you filed? Before this court?
Yes,
lordship.
Yes. When you filed?
So it was filed on
30th June. Why it is pending?
Lordship, the matter was running in the list.
Yes.
So you not mentioned?
We mentioned, your lordship,
Last week
thereafter.
we did.
Last week we mentioned thereafter.
June and you mentioned in September, August.
For the defendant.
Yes. What is the suit for? Plaint, eh? Recovery of amount.
Yes, the amount was 3 crore 64 lakhs.
So how much it has settled?
So
and your counter claim was also there?
No.
No. So what is the total settlement?
No claim against each other, your lordship. With the condition that we withdraw this matter.
No. What is the total settlement?
There is no settlement.
Then?
Kindly see the page.
No, dependent, you also filed the counter claim.
Yes,
so counter claim also there, 84 lakhs.
Yes, lordship.
Then?
Lordship, it has been settled and there are no further.
So that's your settlement. What is the terms?
Your lordship, page 2 of the agreement, your lordship. On page 11 of this joint compromise petition.
Lordship, page 11,
Yes,
point
yeah.
number 2. Yes.
Yes. What is the settlement? Nothing.
Lordship, we have foregone the.
You forgone the 3 crore, you forgone the 84 lakh.
Yes, Your Lordship.
Settlement. Pay the cost to the court. 3 crore rupees without foregoing.
That included, your lordship, loss and damages, so we are not pursuing with that.
Principal amount.
In clause 2 lordship settlement, we have explicitly stated that the SRMB has agreed to forego.
Correct. That's what I'm telling. He has forgone the 3 crore, you forgone 84 lakhs.
No, I have foregone 84 lakhs, he has foregone 3
Whatever
crore.
it may be.
Means
How this court can accept this agreement?
the total claim amount does not include the principal only. The loss and damages are also part of the claim, your lordship.
So how you show your audit? 5 II? How you show the audit? Kindly see 5 II for the purpose of only the extent necessary to comply with the audit, financial disclosure, regulatory. How you show the audit where you are foregoing the 3 crore?
For that purpose only, your lordship, we are praying the terms to be recorded in your lordship's order, so that
Yes.
we are praying the recording of the terms of the agreement, your lordship.
Yes, the contract and
Point we need to clarify.
Other claim is what? Principal amount. Both the parties have filed a joint compromise petition being GA-Com 2 of 2025, stating the fact that during the pendency of the suit and the counterclaim filed by the defendant, the parties have settled their dispute and have entered into a settlement agreement on 22nd of May 2025. Counsel for the parties submitted, in view of the settlement arrived between the parties, the plaintiff is not intending to proceed with the present suit, and the defendant is also not intending to proceed with the counterclaim. So the parties press for disposal of the suit in terms of the settlement entered between the parties. The learned counsel for the respective parties peruse the compromise petition jointly filed by the plaintiff and the defendant, and react with settlement agreement disclosed in the settlement agreement dated in the settlement agreement. The settlement, as per the settlement agreement, both the parties have settled their dispute as follows. Page 11, settlement. Okay. Considering the above, this court find that the parties have settled their dispute by entering into the settlement agreement dated 22nd May 2025, and the plaintiff has forgo his claim made in the plaint, and the defendant has forgo his claim made in the counterclaim. Considering the above, this court find that as the parties have settled their dispute by entering into settlement agreement, accordingly, CS-Com 559 of 2024, GA-Com 2 of 2025 is disposed of by allowing the parties, by accepting the settlement entered between the parties. Accordingly, CS-Com 559 of 2024 is disposed of. The settlement, the joint compromise petition, along with the settlement agreement dated 22nd May 2025, be made as part of the decree. Yes. Gratefully, Your Lordship.
What did I appear for the respondent?
Yes.
For the petitioner, my lord. Refer, my lord, not today, as because Noel Banerjee is appearing in the matter. This is senior counsel. She's in difficulty. She's counsel appearing in the matter. So, my lord, kindly prefer not today only, my lord.
This is a completely malified, mischievous application. Where, my lord,
only prefer not today, my lord.
What is the application? GA4.
Yes, my lord. GA6 and GA5. 18 and 19 are similar, connected matters, my lord.
My lord, for item 19, I am appearing for defendant number 2, Indian Overseas Bank.
Item number?
18 and 19.
No, 18. Let me understand the 18. 18 GA5. Who has filed the GA5?
This application was filed by the applicant, my lord, the plaintiff. For direction, there is a simultaneous arbitration going on between the plaintiff and the defendant number 1, which is me. And thereafter, so in the arbitration, it has been going on since 2009. We are in 2025. They have participated in the arbitration for 16 years. Now they basically want to scuttle payment as far as because the arbitration has been proceeding. And now before the fifth arbitrator, the arbitration is going on. The reply arguments have been started by them. And now they're making an application here saying that as far as the suit proceedings are concerned, the amount in dispute should be kept in abeyance and should be kept out of the arbitration that is going on.
Yes.
So, Malad, this is the situation.
You are filed.
Look, I'll pray that only part not to pray upon
Malad, I'm led by Mr. Banerjee. Malad, if Malad wants
only
to
part
keep
not
it
today, only
tomorrow,
part
Malad,
accommodation, only part one day, man.
Okay, not today.
Malad, kindly, very well.
And as per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear tomorrow.
Great for me.
What about the 90? Same.
Same, my lord, same matters.
19, I am for defendant number 2 bank. My lord, this is the same case. We have no objection if the arbitration is already ongoing. So there is no question of any objection to us.
Yes, same. Yeah, next.
Great.
Record the name of the advocate of the defendant.
Great.
Item number 20, my lord, I appear for the defendant. Lordship's last order was whether if no instructions are forthcoming as regards whether my client is going
Yes, yes.
Lord,
You got the instruction? No.
Lord,
No.
I have got written instructions to the effect that
He will adduce evidence.
Evidence has to be adduced. We have held conference till last Friday also, my lord, tried to explain them. So, my lord, today a very, my lord, if your lordship kindly pauses the my lord, I will not be here, my lord. I will personally not. My lord, I am returning on 31st October. No, my lord, there is some family function.
My lord, I'm for the plaintiff, my lord. This is my application for summary judgment, my lord. On 21st of August, my lord, this matter was placed. I had posed a question that whether the summons was delivered to the. This is a report. Summons has been served upon the defendant on 16th May, my lord. Thereafter, other than that, 2 affidavit of service I have filed regarding this application. Both of them has been served as item door locked. Door locked. Door locked is a good service, my lord. Email service has also been done, my lord. GA1, my lord. The plaintiff, this is my summary judgment application, my lord. The plaintiff is involved in the business of. No, no, my lord. Order 13A, my lord. Yes, my lord. The plaintiff is involved in the business of selling chemicals from 2016-17, financial year 2016-17. The
dealings were started and they were maintaining running and continuous accounts between themselves. At 16, my lord, each and every for the financial year, I have given the bills and the ledger. But my lord, kindly come at page 24 once. That is the ledger for financial year 2016 to 17. 2016 to 17, my lord. That was the first financial year. Yes. Business started. Chemicals. To the defendant. Defendant is involved in the business of running a yes. Then the business was going on, and at page 24, I will find a ledger. This is how I have presented in all of the financial years. Ledger is at the front, and thereafter the invoices and the transport receipts. Now kindly see page 25, 26. These are invoices. All invoices for the financial year 2016 to 17. I'll pitch till page 36. 2016 to 2017, all the invoices are till page 36. Thereafter, page 37, 2017 to 2018 starts. And it goes until 2021 to 2022. That is appearing as page 120. 120, last financial year that the business was going on between the plaintiff and the defendant. Yes, that is my principal claim herein. Yes. As on 21. And thereafter, my lord, kindly see the non-starter report at 145. Non-starter report 145. And I have raised demand notices also, that is appearing as page 139. That was not answered by them. Yes. Yes. And thereafter, mediation was initiated, my lord. Page 145. This notice. And 147, they did not come forward. It is dated 2nd January 2024. Thereafter, I have initiated this suit. And I have issued the writ of summons also. They did not choosing not to appear. I have served them this application twice, both through mail and physically. Claim chart. Interest chart dilam na? And my lord, kindly come to para 21. There I have given the principal sum and the interest component that has been adduced to para 21 of the application. Page 7. Yes, and interest is suit was filed on 2024, my lord. This is suit of 2024. Yes. Yes. My para 21, I have page 7. I have initiated what my claim is. Principal is 39 lakhs 28,000 and interest is 22 lakhs 59,118. And no reply has been issued by them. They have denied the quality. They have used the fruits of my service, my lord. No, they have not denied it. There is no record of that. Page 139, 18th of October 2022, the notice was issued. No reply. Thereafter, mediation was also initiated. Mail I have attached. Page 145, mail was sent to the respondent. They did not appear. Mail is dated 10th October 2023. Two occasions. Item door locked. Door locked is final. That is the endorsement. Yes, each and every year he was paying some amount. That is why running and continuation accounts. Last amount was paid on 21st January 2021. '83, na? Page 83. Yes. Yes, money receipt. 13,97,527. This amount was totally paid in financial year 2022-2021. Last date 8 money receipt 9 January 2 lakh. Last date of payment is 9 January 2021. That is 10 lakhs. It is serially on the left hand side 9 January 2021. No, the last single payment was 9 January 2021. In the ledger itself, 9 January, may I mark and so? Yes. On the previous days, they have paid previous 13 lakh 90.
No, 13,97,000 was paid in the total financial year, 2021. Yes. Yes. That is not the closing balance, man. 45 of it. 36 of it, 36. Not this one. Achha, this credit, Manadu, kindly see, this is the total. Right hand side column is the total. 45 plus 13 comes to 59.90. That was total paid. Left hand side 8006. There is some.
May I clarify? Kindly comes to page 83, my lord. Closing balance is 13,97,000.
Right.
And your lordship may kindly sees the next ledger at 120.
Yes.
Your lordship will get 120, my lord. Kindly sees that closing balance is being carried on, 13,97,000. So out of 59 lakhs, 45 was paid, 13 is due. Last payment was made on 9th of January, 10 lakh rupees. In the at page 83, your lordship may kindly sees. না না ঠিক ঠিক এটা টোটাল আছে এটা টপ ব্যালেন্স শিটে দেখ না হ্যাঁ এই দুটো অ্যাড করে yes my lord 39,000 my lord as on 31st of March 2022 the ledger is of 31st of March
আমাদের প্রথমে আমাদের বলা নেই সামনে দেখাবো কি করবো সেটা এখানে নিয়ে আসবো দেখাবো তো ওটা ইয়ে থেকে বলি
18th October
করতে পারতাম শুনলাম অনেক বড় ম্যাটার আছে আর কিন্তু
yes
তাদের এটা আমাদের লাভ নেই পরে আমাদের অপশনে অপশন কোন জায়গায় এটা তো দিচ্ছি না এটা পরে
security আছে
ওরা
$39, 28 802
हमारा कोई
collapse করেছে ফিক্স ম্যাটার আর ওই নট টুডে হয়ে গেছে না আজকে রেজলিউশনটা দেখাতে হবে Yes, my lord. Yes, my lord. So January তে credit note হয়েছিল extremely grateful, my lord. Extremely grateful. Chapter 13 এ যেতে গেলাম
So this is defendant's application in a suit millet praying for millet an order millet from deleting the name, striking of the name from the area of the defendants because millet I only happen to be a director in the defendant number one company. They had taken opportunity to file opposition millet. No opposition has used.
No, my lord, I could not. I am seeking an indulgence. My vakalatnama could not be filed. That is why it could not be affirmed. Because, my lord, I'll explain. The registry said that the suit registry does not have the entry for the suit. This is a change vakalatnama. That is why they cannot take my vakalatnama on record. I'm filing.
Leave Lena.
It is fixed on 15 September. My lord. Last order. Yeah. I mean,
How did it appear today?
it is wrong.
Oh, it appears it wrongly appearing today, millet. Subject to correction. Last order millet.
I mean, 21st of August.
Very well. Let it appear on 15th in that event.
Great. Leave. এখন দিতে হবে? এইটা এইদিকে পিটিশনের প্রোগ্রাম চলছে সব
The lottery was trying to pass an interim order on 9th of December 2024. So that interim order has been continued from time to time. They filed their affidavits in opposition. A reply is also filed, Lord. Lord, your lordship's interim order is still today. Now, Lord, very briefly, Lord, before your lordship take your lordship into the facts, contract was awarded by the railways in our favor for welding on, Lord, the rails. Now, Lord, these rails which run on the rail tracks, at the ends of the rails, there are wells. Now, these wells, from time to time, they become loose. So, Lord, these tenders are issued from time to time by various railways. Lord, the system which is used is that from the station, Lord, on the movable platforms, our engineers have to go right till the place where the particular welding has to be done. It is welded, and again on that movable platform, it has to be brought back. So, Lord, during the time that the work carries on that particular track, trains cannot run. So, Lord, what is essential, part of the contract is there must be what is known as a traffic block. Depending on how much the railway authorities can give traffic block time to us, we can carry out the work. Now, in this contract, your lordship will find from time to time, we have been requesting for increase of the traffic block time so that we can do the work faster. They've indicated their difficulties. The general conditions of contract, I'll show your lordship, says that traffic block will be given by them as per availability. Rightly so. But then unless traffic block is given, we cannot work. So it's a catch-22 situation. Now the contract contains, as your lordships have seen in other matters, provision for a 7 days notice, a 48 hours notice, and a termination provision. When the contract was entered into, we had to give an earnest money deposit and we had to give a performance bank guarantee. Now, Lord, after giving these performance bank guarantees, we commenced the work. There was an issue with regard to traffic block. There was also an issue with regard to one of the welding machines that became non-functioning, having to be changed. So we carried out work with the altered welding machine. Now, Lord, at one point of time, I'll give your lordship the dates. Lord, they issued a 7 days notice. Lord, after the 7 days notice, we responded. We gave it in details our reply. Thereafter, Lord, they issued a particular certification certifying that the work that we had done was of good quality and that they had no grievance. But immediately after that certification was given by them, they issued the 48 hours notice and they terminated the contract. 7 days notice, then they give us a certification saying work is good, then certification after the 7 days notice. Then instead of giving us additional time because the work was issued, they give us 48 hours notice and they terminated the contract. Along with the termination of the contract, they said that you will not be allowed to participate in any other contracts of the railways in that particular division. So it was almost like a blacklisting, and the fact that your performance bank guarantee will be invoked. Now, this notice by which they said the performance bank guarantee would be invoked was in September, 19 September 2024. Lord, we approached your lordship's court in December 2024. Till that time, the performance bank guarantee had not been invoked. There is no invocation even till date. So, Lord, when we moved your lordship said that since it requires leave under Section 80 of the Civil Procedure Code, your lordship gave leave under Section 80, subsection 2, but without service, lordship would not give an interim order, rightly so. Your lordship gave us leave under 12A, your lordship gave us leave under Order 2, Rule 2, under Clause 12, but Section 80, subsection 2 was given subject to the condition that we have to serve and come back, then
Lord, we served and came back. They had not invoked till then. The Lordship gave an interim order. After the interim order, there have been repeated extensions. They have not sought for revocation of the leave under clause 12. They have not sought to file any vacating application. It will be.
My preliminary objection that jurisdiction point, my lord. That is all the occurrence and other work has been done by Agra jurisdiction, that is Uttar Pradesh. And number two objection is that arbitration clause is there under Malad 64(1). The two has been Malad.
As in,
Yes.
let my learned friend argue. No difficulty.
No.
Yes.
Yes, Malad. Yes, Malad. Your Lordship, kindly come to Malad, page 256. Page 256. এটা ম্যানেজ করেছো কি এটার এগ্রিমেন্টটা ও না আমি করেছি হ্যাঁ ওতে যাচ্ছে পেজ 256 মানে কোথায় না স্ট্যান্ডার্ড জেনারেল কন্ডিশন আচ্ছা পেজ 256 দ্যাট ইজ ডিমান্ড ফর আরবিট্রেশন that is standard general conditions of contract matter. GCC April 2022. That is come malad from malad page malad 151. 252 page malad. That is continuing malad 151 malad. That is standard general condition of contract, and it is malad under clause malad 64(1). Yes, demand for arbitration malad. In the event of any dispute of difference between of parties hereto as to the construction or operation of this contract or the respective rights and liabilities of the parties on any manner in question, dispute of difference of any account or to the withholding by the railway of any certificate to which the contractor may claim to be entitled to, or if the railway fails to make a decision within 120 days, then in any such case, but except in any of the accepted manner referred to in clause 63(1). That is clause 63(1). I again read it. Then continuing this condition, the contractor after 120 days, but within the 80 days, he is pending his final claim on dispute matter shall demand in writing that the dispute or difference to be referred to the arbitration. That is clause there. And then the subsequently 63(1) you also kindly come to Malad. 63(1) Malad, that is page Malad 254 Malad. The clause 63 Malad, the clause of application applicable in the tender having advised value less than equal to rupees 50 crore. Second condition is that all dispute difference of any kind whatsoever arising out of any in construction with the contract, whether the process of any of or after it completion of, and whether before of any other determination of the contract shall be referred to the contractor, to the chief engineer or divisional railway manager through notice of dispute. That is the process, my lord. Provided that no such notice shall be served later than 30 days after date of issue of completion certificate. And then by engineer, chief engineer, divisional engineer shall within 30 days after receipt of contractor notice of dispute notify the name of counselor to the contractor. The counselors shall be assist to the parties to reach and smell bit that is not clause 2.
Amicable settlement.
Amicable
Amicable settlement in an independent or impartial manner within the terms of contract. That is conciliation clause, Balat. Page 254. Para 4 is that, Balat, if the parties. Thank you. If the parties reach agreement on the settlement of dispute, they shall draw up and sign written settlement agreement duly signed by the engineer in charge, contractor, or conciliator. When the parties sign the settlement agreement, it shall be final and binding on the parties. Then fifth clause is that, Malat, the parties shall not initiate during the conciliation proceedings any arbitral or juridical proceeding in respect of dispute that is subject matter of the conciliation proceeding. Next, Malat, the conciliation proceeding shall be terminated as per section 76 of the Arbitration and Conciliation Act. That is there, Malat. And next, Malat, that is important, Malat, 63(1). That is matter finally determined by the railway. All the dispute and difference of any kind of whatsoever arising out of in connection with the contract, whether during the progress of work, after completion, whether before and after determination of the contract, shall be referred to by the contractor to the GM, that is general manager, and GM shall within 120 days after receipt of the contractor representation make a notified decision on any matter referred to the contractor in writing, provided that the matter for which provision has been made in clause 7, 1, 8 and other that is clause, and the standard general condition of contract or any clause state except of matter of the special condition of the contract shall be deemed to accepted matters. Next page, matter not at decision of the railway, therefore final and binding of the contractor on the contractor, provided further except 63(1). Yes, ma'am. Yes. Yes, ma'am. Yes, ma'am. Yes, ma'am. No, my lord. If we kindly come to, my lord. Next, my lord. কত এবার সে কালি কাম টু সিট অফ আরবিট্রেশন, my lord. Yes, সিট অফ আরবিট্রেশনের মধ্যে ক্লজ গুলো দেখা আছে, that will all
one D, the place of arbitration. The place of arbitration would be within the geographical limit of place.
So kindly come to page 257. Yes, ma'am. That is clause 64(1), subclause 3D. That middle portion, Malat, 257. Place of arbitration. The place of arbitration would be within the geographical limit of the division of the railway, where the clause of section arose, and headquarters of the concerned railway or any other place within the written consent of both the parties. That is mentioned in the Malat 64(1) 3D. So, Malat, no question of Malat arose regarding Malat filing of cases as well as Malat jurisdiction point, Malat. That preliminary objection, Malat. Yes, Malat.
Lord, the challenge is in the suit.
My claims arise out of the challenge to the notice of termination.
নিয়ে নিলে ওটা আর আছে
Lord, so far as the notice of termination is concerned, Lord, if your Lordship kindly has a look at to the notice of termination, your Lordship will find that, Lord, at page 418 of volume 3. But I'll not trouble your Lordship with the merits of the termination notice. Lord, please have a look at the second paragraph. Since the period of 48 hours notice already expired, the above contract stands rescinded in terms of clause 62 of the standard general conditions of contract. Now, Lord, with this in mind, Lord, please come back to Lord the general conditions of contract, which are at page, which my learned friend was showing to your Lordship from Lord page 250 onwards. Yes, Lord. Lord, please come to Lord page 253, 254. Clause 63.1 at the bottom of the page. All disputes and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completion, and whether before or after the determination of the contract, shall be referred by the contractor to the general manager, and the general manager shall, within 120 days after receipt of the contractor's representation, make and notify decisions on all matters referred by the contractor in writing. This is a standard. But the next portion is important. Provided that matters for which provision has been made in terms of clauses such and such, but please ignore the first few, but please see 61 subclause 2. 61 subclause 2, 62 subclause 1. Of the standard general conditions of contract or in any clause stated as accepted matter of the special conditions of the contract shall be deemed to be accepted matters, matters not arbitrable, and decision of the railway authority shall be final and binding on the contractor, provided further that the accepted matters shall stand specifically excluded from the purview of the dispute adjudication board and arbitration. Now, Lord, my dispute, if your Lordship please has a look at 62.1, which your Lordship will find at page 251 bottom. This is the termination clause. Page 251. Towards the bottom of the page, Lord. Determination of contract owing to default of contractor. If the contractor should, then Lord, please ignore the conditions under which the termination can take place. And then Lord, please see the next portion. Then and in any of the said clause, the engineer on behalf of the railway may serve the contractor with a notice in writing to that effect. And if the contractor does not within 7 days, that's a 7 days notice, after delivery to him of such notice, proceed to make good his default insofar as the same is capable of being made good, and carry on the work or comply with such directions as aforesaid, of the entire satisfaction of the engineer, the railway shall be entitled after giving 48 hours notice. So this 48 hours notice is also here. In writing under the hand of the engineer to rescind the contract as a whole or in part or parts as may be specified in such notice, and after the expiry of 48 hours notice, a final termination notice, as the case may be, should be issued. So, Lord, my challenge is your Lordship will find from your Lordship's first order also is to my 7 days notice, the 48 hours notice, and the termination notice. These all fall, Lord, within the purview, Lord, of 62.1. And 62.1, as your Lordship has seen from page 254, clause 63.1, third last line, is one of the clauses mentioned here as an accepted matter. Therefore, even if I want to, I cannot go to arbitration in respect of the sum and substance, the subject matter of this dispute. I cannot go to arbitration. So, my lord, if a decision is taken by the railway authority, it is final insofar as arbitral tribunal dispute adjudication board is concerned. My only remedy is a civil suit. No, that is my main submission. Alternatively, even if I assume that my disputes, in the unlikely event my learned friend is able to convince your lordship that the disputes fall within the arbitration, the scope of the arbitration agreement, even then a civil suit is not a bar. Because if there is an arbitration agreement on a matter in which I have filed a civil suit, my learned friend's remedy is to file an application under Section 8. My learned friend may not file an application under Section 8, in which case both parties will have their disputes adjudicated in the civil suit. It is only when my learned friend's client files a Section 8 application, then the matter is to be referred to arbitration. But unlike the 1940 Act, where there was provisions of 34 and 35, both cases it could go to either suit or arbitration. Here, Section 8 is specific. So, here the railways have chosen not to file an application under Section 8. At least till today, there is no application under Section 8. So, either way your lordship looks at it, even if your lordship feels that this is a dispute covered by the accepted clause, then there is no difficulty at all. The lordship will have jurisdiction to entertain the suit and the interlocutory application. If the lordship feels that no, it is covered by the arbitration clause, even then it is at their option to elect to file an application under Section 8, and they have elected not to do so. So they have chosen to submit to the jurisdiction of the civil court. So that is so far as the arbitration issue is concerned. Now, so far as the issue of jurisdiction is concerned, now, had this been a civil suit between my client, the plaintiff, and the railways alone, then the issue would have arisen as to where the reference to the seat of arbitration is irrelevant. Once your lordship comes to a finding that arbitration does not lie, or in any case there's no Section 8, that becomes irrelevant. Now, here your lordship would find. Now, insofar as the parties are concerned, if your lordship please has a look at the cause title, an important part of the array of parties is the Axis Bank, third party who is not part of the agreement with the railways, and particularly because the lordship knows in a bank guarantee, the bank which issues the guarantee, that the bank is not part of the principal agreement. The bank is subject to an agreement between myself and the bank, and the railway is threatening to invoke that guarantee issued by the third party bank. So I have to make the bank a party, and once I make the bank a party, a third party, because I'm seeking an injunction on the bank guarantee which has been given by a third party bank, I cannot but make the bank a party. And the moment I make the bank a party, which is because it is a proper and necessary party, because of Sukanya holdings, I cannot segregate the causes of action, I cannot segregate the parties. So also, therefore, my third limb of argument, that in any view of the matter, arbitration will not lie. So, these are my three limbs of arguments with regard to the point of maintainability. So, this is on the preliminary point which they have raised. If your lordship permits me to go into the merits, or I can continue whenever I'll. Now, so far as this is concerned, so far as my learned friend is prompting me to also address your lordship on the forum which I have approached, there my argument is the same.
That is my important point, Malad.
Of course, I'll address all the important points.
All Agra cases come to Calcutta. Calcutta cases go to Agra.
Apprehensive. Yes. This is not a court which shuts out any of the parties. So I'll address your lordship, and your lordship will certainly hear that. Now, my lord, so far as the cause of action is concerned, the cause of action also includes the notice of termination by which there is a threat of invocation of the bank guarantee. Now, the moment I make the third party a party to the suit, the bank is within jurisdiction, not in Park in Theatre Road. Issued from Theatre Road in Calcutta. Now, my lord, if your lordship is please. Yes, yes. This is in AC Market, Theatre Road. First air-conditioned market in Calcutta. Now, that apart, Lord, the letter of award has been received within, and the very importantly, the contract has been digitally signed by both parties. They signed it first, and they sent it to us, and we signed it within jurisdiction. That is also pleaded, to which there is no objection.
No, that is I'm objecting, Mr. Ektu, they wanted to pull.
Get your chance to argue. So, Lord, so far as the now, Lord, coming back. So, Lord, there was Lord, 7 days notice, as I said. Thereafter, a certificate which certified that the work has been done well. Thereafter, 48 hours notice. Thereafter, termination notice. Post termination notice is of 19 September 2024. Lord, we approached your lordships in December. Till when, Lord, there had been no invocation. Your lordship was pleased to grant an order of injunction, and thereafter the injunction has continued till today. It is continuing. Now, Lord, two things, Lord, which weighed with your lordship while your lordship passed the interim order, which I'll place for your lordship's consideration. Two important things. One is, rather, in fact, three important things. One is, Lord, there is no invocation of bank guarantee. There is only a threat of invocation of bank guarantee by a letter that we are terminating, and pursuant to the termination, we reserve the right to debar you from future contracts and to invoke your performance bank guarantee. Had there been an invocation of the bank guarantee, then, Lord, I would have been in difficulty because I would have to convince your lordship with regard to fraud, special equities, those tests which I have to satisfy a court if bank guarantee has been invoked. Here, Lord, I am at a stage before that where there is only a threat of invocation. So, Lord, I have to satisfy your lordship with regard to prima facie tests. And the two prima facie tests which your lordship was satisfied, at least at the ad interim stage, firstly, my lord, is one with regard to the certification of the quality of the work that we had done. And secondly, that admittedly, more than the value of the bank guarantee was lying with them in deposit, which even today is lying with them in deposit. And I am now aided by their affidavit in opposition, because in their affidavit in opposition, they have not denied this. Lord, may I come to these parts to show your lordship, Lord, the fact that after your lordship passed the interim order, based on these two considerations, the certification and the fact that they were already secured more than the amount of the bank guarantee, there is no change in position. Now, Lord, let me show your lordship, Lord, the 7 days notice, Lord, the certification, and Lord, the others will follow. I'm coming to the terms of the contract and the factual disputes a little later, Lord. The 7-day notice, your lordship will find at page 368. Lord, this is part of volume 3. Lord, please have a look at page 368 in volume 3. I will have to take your lordship into the factual disputes a little bit, but I need to satisfy your lordship's conscience with regard to the considerations which weighed with your lordship for extending the interim order. Lord, please have a look, Lord, at the 7-day notice, which is 368. This is 16th August 2024. Aforesaid work was awarded with a contract agreement under reference 1 within completion period of 15 months. That is 15 November 2023 to 15 February 2025, with total 7615 kinky wells, which were to be removed within the above said completion period, but approximately 9 months has passed. The lordship will find factual dispute, which I shall refer to later when I come back. Let's see the last paragraph. Since you have failed to abide by the instructions issued to show adequate progress of the work, you are hereby given 7 days notice in accordance with clause 62 of General Conditions of Contract to make good progress, failing which further action as provided in clause 62 of the Standard General Conditions viz. Terminate your contract and complete the balance work without your participation will be taken. So clause 62 is also an accepted matter. Now thereafter, my lord, please come to the certification. Now there's a reply at page 370 which is on facts, which I won't trouble your lordship now, but please come to the certificate, lord, which is of 27th of August 2024 at page 410. Page 410, the certification. Lord, please see the certificate which has been issued digitally at 410 top. Number 1, certified that the work has been satisfactorily done by the contractor. The other terms and conditions are same as for original tender conditions. Increase, decrease in quantities are as per actual site requirement. No banned items taken into account except already existing in the agreement. No undue benefits given. Certified that this addendum, corrigendum is essentially required. It is certified that this work will be executed only after sanction of ANC. Contractor has engaged engineering postgraduate, graduate diploma on this work as per terms of the contract agreement. No railway piped wire has been supplied to the contractor. No railway labor, plant, machinery, equipment loaned to the contractor. No railway material, the cost of which is to be recovered, were issued to the contractor. No audit, accounts, vigilance, paras pending against these works. Material used for the works confirmed IS specifications. But I would beseech your lordships not to have kindly note 1, 3, Lord, 7 and 12. 12 because one of their allegations is that you changed the equipment. Now, Lord, with regard to this, Lord, if your lordship kindly has a look at my petition, paragraph 19 at page 52, where I've, Lord, pleaded about this.
Para 19.
Page 19, paragraph 52.
Yes.
Your lordship will find, Lord, the pleading of annexure AA is in paragraph 52. I'll not trouble your lordship further. Lord, please come to, Lord, the affidavit in opposition. And Lord, please come to page 20, paragraph 35. Page 20, paragraph 35 of the affidavit in opposition. Yes, yes,
Yeah, you.
Opposition. My lord has got it.
Page?
Lord, page 20. Okay.
Yes. Para 36.
Para 35.
No comments.
No comments. So with regard to certification,
Yes. Admit.
It's admitted.
Yes.
Now, Lord, in this connection, Lord, please now come to the second aspect of the matter.
Yes.
Which is, Lord, with regard to the amount which is due and payable to us. Lord, this is the second prima facie case test that your lordship took into account. Lord, please have a look, Lord, at, Lord, paragraph 64 and 65 of my petition.
Yes.
Your lordship will find, Lord, paragraph 64 of the pleading is, the petitioner states that due to illegal termination notice, the petitioner had already suffered a substantial loss, including its claim of 67,26,257 for successfully carrying out 645 numbers of wells, which still remains unpaid. The petitioner states that on November 4, 2024, principal sum of 67,26,257 is due and payable by the respondent number 1 to the petitioner, and interest to be paid separately thereupon till its actual realization only with regard to the wells already completed. The petitioner is also entitled to substantial sums on account of idle establishment, both on-site and off-site, loss of profit, and other claims towards compensation on account of the loss and damage caused to the petitioner. Now, the other claims are unliquidated claims. 67,26,257 is almost double the amount of the bank guarantee, my lord. Please, my lord, if your lordship kindly notes, my lord, the amount of the bank guarantee is only 39,74,484. 39,74,484.
39 lakh.
39,74,484.
Yes.
Now, Lord, please have a look at what they have said in their affidavit in opposition. They say blandly, nothing is payable. There's no dispute done. If your lordship please has a look at page 23, paragraph 44 of their affidavit in opposition. No specific denial, just a bland denial. Your lordship will remember the paragraphs I placed are 64 and 65. They are all part of paragraph 44.
Yes.
With reference to statements made in paragraph 64, 65 and 66 of the stay petition, save and except those are the matters of record, I dispute and deny all the allegations. I say that Rahi Infratech Limited, Kolkata has executed 645 wells. This is now an admitted position now. With machine of H1000 and K920, HK and QAPs of both the machines has already withdrawn by RDSO Lucknow on date 3rd August 2022. As per page number 37, para 24.1 of the contract agreement signed between Railway and Rai Infratech Limited, Kolkata, general QAP for the flash butt welding plant, excluding details of operators and standardized welding parameters proposed to be deployed by firm, should be approved by RDSO before the tender opening date. The mobile flash butt welding plant owning firm can approach RDSO directly and can get the general QAP approved by RDSO before participating in tender. This approved general QAP is to be submitted along with tender document, without which tender will not be considered. At the time of submission of tender, QAP of machine K922 was attached in the tender documents, copy attached as Annexure L, which was never deployed by Rai Infratech Limited, Kolkata for the commencement of work. Machine number H1000 and K920 HK were deployed by Rai Infratech, Kolkata, and QOPs of both these machines have already been withdrawn by RDSO on date 30th August 2022. And Mrs. Rai Infratech Limited was aware of withdrawn of QOPs of these machines. Lordship, kindly remember, Lord, the certification, Lord, is of 27th August 24, 2 years after this. Hence, all wells done by both the machines are of no use of railways. As per contract conditions, wells were required to be executed with machines having valid approved QOPs from RDSO Lucknow. Hence, contractor is not entitled to pay for these wells.
Yes.
So, all they say is that you did the work by a different machine. Therefore, these wells are of useless. Therefore, I presume they must have removed these wells, because every day thousands of passengers are going on these rails, which have been made by us between 2023 and 2024. I presume they must have removed these wells because they are danger to the safety and security of thousands of our citizens. I'm sure the railways in its wisdom would not have allowed cargo and human lives to be endangered because of the illicit work done by a petty contractor. So they would have removed it and got it redone by somebody else. We have made the specific averment.
That is the trial matter.
We have made a specific averment that the wells done by us are still functioning are still being used, and every day trains are running on this. That apart, no, there is no specific denial of the sum of 67 lakhs and odd, which we claim to be due and payable to us, except that they say that because the wells.
No, in the notice they have not given this allegation.
No, nothing.
This is not the allegation in either 7 days or 48.
No, this is creation in the post suit.
Okay.
Post suit creation. Now, Lord, this is Lord, as of as of the date of termination was 67,26,000. Now, Lord, wells have been done from time to time. May I take your Lordship a little back to, Lord, a previous date of September 2024. Termination, Lord, is of November 24th. November is this date. Now, please come to September 2024. Your Lordship will get this at, Lord, page 396. If your Lordship please takes page 396. This is part of a document which is on record. Lord, the documents, Lord, starts at page 393. It's a letter by us.
Yes.
And Lord, if your Lordship please comes to page 396. Lord, if your Lordship sees the response, the middle of the page, there are some, the marks are there.
Request for release of running bill.
Yes, my Lord.
66/21/970.
Yes, my Lord. That was what was there as on the date of this notice, Lord, which is 6th of September 2024. And your Lordship will find 635 wells were there, 635 wells. As on 4th of November, it is 645 wells, which they also admit in their paragraph, 645 wells. And naturally, the amount has increased. And this amount is double the amount of the bank guarantee.
Yes.
Lord, if your Lordship takes your Lordship's interim order, Lord, these were the two conditions, Lord, which weighed with your Lordship while passing the interim order. Lord, I have shown your Lordship the affidavit in opposition with regard to both these aspects. Lord, there is perhaps not, in my respectful submission, no change in situation with regard to both the prima facie issues, Lord, on the basis of which your Lordship passed the order. Now, Lord, now is not taking your Lordship into the further facts of the matter, Lord. Now, Lord, so far as this is concerned, Lord, I would have to go back to this issue of the traffic, Lord, block.
Yes.
Lord, would your Lordship be continuing today? Your Lordship has
Yeah,
another
fix it,
matter,
yeah.
3:45, your Lordship has a matter fixed.
Counsel for the defendant has raised the objection with regard to the maintainability and argued the matter with respect of the maintainability of the suit filed by the plaintiff. Counsel for the plaintiff has argued the matter by giving the reply to the maintainability as well as on merit, but due to paucity of time, hearing could not be completed. Accordingly, case is adjourned. अभी है ये तो नहीं होगा ना वेकेशन से पहले होगा कब है 9 September 3:45.
Lord, 9th, I'm in some difficulty because of.
I am also, Malad. I am also.
You are also. So after vacation?
No, Malad.
Lord, immediately on reopening.
Immediately. No, Malad. Before vacation, Malad.
Before vacation.
Before 26, Malad. Any date, Malad. Any date. Any date.
Not after Mohala.
3:30.
Not after Mohala. Not after Mohala.
11 September.
Yes.
At 3:45.
3:45. Yes. No problem, Malad. My friend has problem because of dog. Dog. Just take it.
11 আমি দিল্লি চলে যাচ্ছি মানে প্লিজ ডোন্ট কিপ ইট আমি দিল্লি চলে যাচ্ছি
ও আচ্ছা 12
না আমি 11 12 তারা থাকছি না not 15 onwards any day if your lordship has a time otherwise immediately on reopening
15.
15, yes, sir.
After 15 বলতে
No, 15, 15 থাকবে তো,
15 onwards. 15 at
Junior will, my junior will not be there, my lord. Then 9th, my lord, no problem, my lord. 9th.
16th
16th.
September at 3:45 p.m.
Deeply obliged.
Interim order is extended till 16 September 2025 or until further order, whichever is
16 November. না না 16 সেপ্টেম্বর ও দেরি করে ভুলে যাবো
yes.
আবার পড়তে হবে এসব ঢুকিয়ে দাও
Party number 9.
I'm for the plaintiff, my lord. My lord, I am led by Mr. Shah. So long he is on leave, so may I begin?
Yes.
Now, my lord, I'll address only the points raised by my learned friend in the last two occasions. Now, and my lord, one very humble request, my lord. This matter has not been marked as part heard. This matter has not been marked as part heard. In case today it is not over, then my lord, that is a small indulgence I am praying for, my lord. Because we are almost done. My learned friend has finished. I'll also not take much time. But in the event, it is not finished today.
Why you persons are worrying about this? Okay.
My lord.
Let's first conclude.
Now, my lord, before I go into the argument of my learned friend, I just recapitulate the entire thing in a very nutshell. This is regarding an insurance claim of potato cold storage. Here, there are two insurance policies. One is insuring the plant and machinery, refrigeration plant and machinery, and the other is the stock of potato. Now, these two policies were taken from the same insurance company, that is a defendant, and before and this is an undefendant suit. And before insuring the plant and machinery of the cold storage, the insurance company conducted a survey to see the fitness of the equipments, and a certificate was issued. A certificate of fitness was issued by the surveyor appointed by the insurance company, wherein specifically the portion that is damaged, the items that were damaged in the plant and machinery were also found to be in sound condition. So that document is an exhibit with the plaint. And my lord, here, so far the claim is concerned, before I go into my learned submissions regarding the claim, my learned senior has already submitted that out of the claim items in paragraph 58, item number 7 falls within item number A. So item number 7 we are not pressing. That is additional interest we are not pressing, because if we have paid for 12% interest, and that will cover item number 7 as well. And another claim is regarding damage repair cost for chamber number 3 where the accident happened. So that claim also we have made an application which is also pending under order to rule 2, because we made that claim on the basis of quotation received from the engineering firm who had to be awarded the repair job. But due to paucity of funds, that chamber could not yet be repaired. So the expenses is not yet incurred. So we have made an application under order to rule 2. That is also we are not pressing in this suit. So these two items, that is number is GA8, my lord. And so our claim is substantially reduced. The claim comes to, as in paragraph 58, on plant and machinery, 6,103 rupees. And on the stock policy, 7 crore 92 lakhs, 29,155. My lord, that is in page 24.
Yes.
My lord, item 1, the plaintiff is pressing. Item 2, we are pressing. Item 3, that is also we are pressing. That is a computation of interest for that particular period. And in the prayer also, we have prayed for interest.
So only you are not pressed the 6.
My lord, we are not pressing 6 and 7.
7 also.
7 also. Because my lord, 7 comes within our prayer for interest. Till disposal of the suit.
Yes.
So, my lord, if your lordship comes to the prayer at page 27, with the principal amount, which
1263.
Yes, my lord, which has been stepped down and which has been reduced, we have paid an interest at the rate of 12% per annum. Now, my lord, I have in my evidence, I have shown, I have filed the contract with the bank, the loan sanction letter, and also the contract with the non-banking financial institutes from where I have taken additional loan to pay compensation to the potato farmers. So I have proved those 2 documents, and those 2 documents taken together, the average interest comes to 12%. And there, and further to that, as per the IRDA regulations of 2017, IRDA Protection of Policyholders Interest Regulation 2017, the insurance company is liable to pay 2% above what is the bank rate. So this is a reasonable rate of interest we have paid for your lordship. Now, my lord, I am coming to my learned friend's argument in the last occasion. My lord, his first submission was there was a misjoinder of party as the dispute is between the plaintiff and the surveyor. And the insurance company cannot go beyond the surveyor. That was the specific submission of my learned friend. Now, my lord, under section 64 UV, I'm not carrying the Insurance Act, but under 64 UV, an insurance company is required to take a report from a licensed surveyor before settlement of a claim. And there are category of judgments that the surveyor's report, the survey report in insurance cases is in the nature of a third-party opinion. The insurance company is not bound by it. Insurance company may discard it, insurance company may accept it. And if the insurance company chooses to deviate from the surveyor's recommendation, chooses to disagree from the surveyor's recommendation, then they have to record reasons. And I'll in this matter, my lord, I'll show that so far the plant and machinery claim is concerned, surveyor has recommended payment. An insurance company, without assigning any reason, has repudiated the claim. So insurance company itself has disregarded the surveyor's report. Yes. So this first limb of submission is contrary to law. The contract is between the plaintiff and the insurance company. So my lord, surveyor is a third-party agency appointed by the insurance company.
Yes.
Yes. My lord, Mr. Shah is online, my lord. He is joining on.
Yes.
And my lord, there is our submission is there is no misjoinder. That point was not taken by filing a written statement. My lord, Mr. Shah is.
Yes, yes.
Mr. Sen, please go ahead. But my lord, with the greatest respect, I'm not claiming against the surveyor. My claim is against the insurance company. So I don't need to make the surveyor a party. So my lord, the question of misjoinder does not arise. My lord, let Mr. Sen argue because my lord, I'm a little handicapped. I'm not my lord, there in court. My lord, I shall try to supplement whatever is required, my lord, if necessary.
Okay.
Now, my lord, there was the second argument of my learned friend was that the plaintiff has not filed the certificate under Section 65B of the Indian Evidence Act in respect of the electronic documents. Now, my lord, the Section 65B certificates were filed along with the plaint. These were filed along with the plaint, and in the affidavit of evidence in chief of plaintiff's first witness, PW1, in respect of, in para 25 of the affidavit, it has been categorically stated that in respect of the electronic documents, a Section 65B certificate has been filed. Now, there was no cross-examination by the defendant on the contents and truth of the Section 65B certificate filed along with the plaint. Only a question was asked that whether the plaintiff has filed any certificate under Section 65B with respect to the electronic documents, and the answer was yes. That is question number 244 of PW1, my lord. PW1 or 2?
44.
244, my lord, of PW. 2 or 1? 2. PW2, my lord.
Yeah, I don't think your lordship has to be troubled by this because, my lord, the documents which are sought to be proved through the mode of 65B have not been disputed. So, my lord, that becomes a really academic exercise. My lord, really the certificate does not have to be proved. The certificate is a mode of proving the document, and the documents themselves have not been denied. There is no cross-examination with regard to the veracity or the genuineness of any of the documents.
Yes.
And these documents have gone into evidence without objection.
Yes.
Now, my lord, the third submission of my learned friend was the plaintiff has filed a writ petition challenging the rate of potato as determined by the state government, and therefore the the claim of the plaintiff is speculative. Now, my lord, that argument was also made in respect of a prayer for inquiry. A prayer for inquiry regarding the rate of the quantum of loss suffered by the plaintiff. Now, my lord, this writ petition is in respect of the rate of potato, which is higher than the insured value per quintal of potato. Now, my lord, we have disclosed documents, we have proved documents that in cold storage, potato cold storage business, it is a government which determines the insured value of potato per quintal, and the Oriental Insurance Company is a party to that proceedings. So, in that writ petition, our prayer was that state government can impose compensation, can determine compensation only at the rate to the equivalent to the insured value as fixed by the government only. They cannot fix a higher rate. That is a bone of contention in that writ petition. But in this suit, we are not claiming what government, the rate of compensation as government has determined and we have challenged. We are claiming only the insured value as per the contract, insurance contract.
What was the insured value?
My lord, 1370 rupees, 1370 per quintal.
1370
per quintal. Out of that, 70 is rent and 1300 is insured value of potato.
No, the government had fixed a much higher rate. We are saying that it should not be higher than 1370. In any case, our claim is confined to 1370, which is the insured value.
Well, that document is in annexure, exhibit number. Exhibit A, my lord, that is page 1A.
So whether they are denied with regards to the claim with the 1300 per quintal?
My lord?
They have denied with regard to the...
Yes, my lord. Yes, my lord. Our claim was 1300.
No, not your claim. Not your claim with regard to the rate of 1300.
No, they are not denying.
They are not denying.
They are not denying it, my lord.
They are only saying that the claim is speculative because you have filed a writ petition challenging the rate fixed by the government, which in any event is much higher than 1370 per quintal. We are saying that whether it is higher or not is not material, because we say it should be 1370, and 1370 is the insured value per quintal.
Yes. Now, my lord, the fourth limb of submission of my learned friend was that there was no accident. The damage to the nut and bolt of the flanges of the main expansion valve was due to wear and tear. And that argument was based on the word used by the surveyor as also the insured, that there was a failure in the valve. So, as I have understood, the crux of the submission was failure cannot be an accident. It was a wear and tear matter. Now, my lord, in this regard, my learned friend has referred to one document, that is a claim file, claim form submitted by the insured while the survey process was on. Page 112. My lord, it is in the first volume of the judge's brief. Page 112. It starts from page 111.
Yes.
Well, this is a claim form. It's a template claim form given by the insurance company where the insured has to fill up. Now, my lord, my learned friend has relied on, it is exhibit N. My learned friend has relied on the box regarding what other action is being taken to minimize the loss. It is before that there is what is a describe the nature and cause of deterioration of stock. So what is the loss? The nature of loss is in the first box. So far, the portion my learned friend had relied on is what actions, post-loss action taken by the insured, the plaintiff, to minimize the loss. Immediately, vacuum process was started with the help of diesel engine to evacuate the leaked ammonia gas. And after half an hour, when the gas was evacuated, our maintenance team went inside the chamber number 3 of the 5th floor and opened all doors and windows for fresh air. And further, they found that the nut bolt of the flanges were unthreaded, and the main valve of the liquid line of the chamber number 3 on ground floor inside the machine room was also found damaged. So, my lord, the valve of liquid line of the chamber number 3 on ground floor inside the machine room was found damaged. So I have checked the dictionary. Unthreaded means separated. Separated. So something breaks, it separates. And now, my lord, the person who has filled up, or none of us, our mother tongue is not English. We don't go into the.
Who has filled up this?
My lord, it is Mr. Van Bhattar.
You only.
I filled up. So, my lord, here the surveyor appointed by the insurance company himself is saying, he's saying that there was a failure in the nuts and bolts which damaged the valve. The liquid came out, the ammonia gas came out from the damaged valve. And in the survey report, he has affixed a photograph of the damaged valve and the broken nut of bolt. It is not a wear and tear nut, it is a broken.
Whether it was a joint with the nut and bolt.
My lord, it is in the inspection report itself.
The damaged portion, if this wall is joined with the help of any nut and bolt, so the nut was open and lying.
No, my lord, the nut broke because of pressure. That is our specific case. In page 129 of the survey report, and the defendant has not raised any issue with regard to these findings. If they had to depart from the findings of the surveyor, they had to seek a clarification under IRDA regulations with a copy to me. So no issue was raised with regard to these findings, actual findings of the surveyor. My lord, 129, the photograph of the valve which was replaced, the broken valve is given, it is broken, it's shown broken. And he's gasket.
Where is the original?
Cracked.
This was exhibited.
My lord, this was given to us, a photocopy was given to us. We had filed, we have given a notice to produce for production of the original. They have not produced it. And that notice to produce has been proved, my lord, in evidence. So this is a gasket cracked and a cracked gasket. It is cracked because of pressure. And it was a specific case in our pleading and in evidence that due to pressure, sudden rise in pressure, the gasket cracked, damaging the valve. Now these submissions, my lord, that was made. And my lord, one more thing. Before the insurance company, my learned senior had already shown this document. Before the insurance policy was issued, insuring my plant and machinery, the insurance company appointed a surveyor to check the fitness of the machinery. And that is in page number 60, my lord. Yes. My lord, this report is of 8th May of Sujan Satra. He is appointed by the insurance company. We received a copy of this from the insurance company. In respect of these also, we filed a notice to produce, which was not produced. Now, my lord, this is a report regarding the fitness of each and every equipment and part of the machine. My lord, kindly come to page number 63. That is item number 61. All valves, pipelines, fittings, etc. Condition is okay. Now, my lord, remarks in the remark portion in the bottom. All the above machineries are found as sound and good running condition with full efficiency output.
Yes.
This report was of 8th May. My damage was 19th May.
Yes. Yes.
So, first of all, my lord, my pleadings have not been disputed, and it is insurance company's report itself, pre-loss and post-loss report shows this was in sound condition, question of wear and tear, and after the loss, it was shown it was broken. Now, my lord, I am coming to the next portion, next submission of my learned friend, that contamination can be covered.
Has the insurance company obtained report, expert report?
Survey report, my lord.
Only the survey report.
Okay. Surveyor found it was broken due to sudden rise of pressure, and that report was not contradicted by any expert or forensic report.
Yes.
They had an option, and they had an option to seek a clarification from the surveyor under IRDA regulations of 2017, 15.2, I believe. 15. My lord, I'll refer to the regulation number. We'll file a notes of argument. We'll mention that in IRDA regulation number 15 of 2017 regulation. It is provided that if the insurance company disagrees or finds discrepancy or incompleteness of any of the findings and observation of the surveyor, they will write back to the surveyor within 15 days from receipt of the report to seek a clarification or correction. That was not done by the insurance company. Well, it is 15.6. It is 15.6, regulation 15.6. My lord, may I hand up a copy of the regulation?
Along with the you that at the time wrote the note.
My lord, if I'm just reading out, if an insurer on receipt of a survey report finds that it is incomplete in any respect, he shall require the surveyor under intimation to the insured to furnish an additional report on certain specific issues as may be required by the insurer. Such a request may be made by the insurer within 15 days of receipt of the final survey report. provided that the facility of calling for an additional report by the insurer shall not be resorted to more than once in the case of a claim. No such report was called for from the surveyor. Now, my lord, the next submission, I have not put it chronologically, but the next submission, as I have noted, was regarding contamination. Whether contamination to be covered under insurance policy required a prerequisite of rise in temperature. So that is a matter of interpretation. That is purely a matter of interpretation, my lord. My learned senior has made lengthy and detailed submissions on that. I will not go into that. I will refer to only one document regarding one clause of the policy, which my learned friend for the defendant had relied on. So I'll show why that is not applicable. But before that, my lord, my learned friend had made several submissions, which I think is beyond the scope of pleadings of this. There is only pleading of the plaintiff in this suit because it is undefended. That there was an allegation was made that suit is pre-planned as plaintiff is trying to cover operational expenses of loan is total loan is rupees 7 crore 28 lakhs, whereas my operational expenses are 2.5 crores. So the question was raised, and I was hearing my learned friend that he has a banking background, so it came into his mind that why this 5 crores, why this additional 5 crores was got sanctioned. Now, my lord, I'll show that. First of all, bank has not raised any issue with regard to my plaintiff obtaining 7.28 crores. Neither there is a dispute with the bank regarding the repayment or utilization of fund, but because the insurance claim was repudiated and we had to pay hefty amount, around 7-8 crores.
You accepted the premium of
Yes,
the 7 crore 28 lakh when it was insured. Your lordship, it was not disclosed, and even in the exhibits they have not disclosed audited financials for that year. No, that is different thing. We accepted the premium just for the insurance. We accepted, lordship. And your acceptance means you have taken the premium of the calculating the 728. No, your lordship, it was not disclosed. It was not disclosed. What? The loan amount was not disclosed to us. So how you calculated the premium of the insurance? The insurance premium is calculated. First of all, the rate is decided by the government of India. Correct. And the risk is covered, not the loan part. The rate is with regard to the quantum. Lordship. Quantum. 7.28 crores is the loan part, which we were not aware about. What we were covering, the plant and machinery and the stock, the potatoes. This 7.28 crores suddenly increase of 5 crores before taking insurance. We do not have any idea about it. Why that was taken?
My lord,
Loan. Yes, your lordship.
My lord, I'll explain. My lord, first of all, insurance company is not holding the brief of bank. Bank has not come up disputing my bona fide in taking this loan. First is that. I'll explain, because if my learned friend had read the document which I have exhibited, the contract with the bank, it would have been clear. Insurance company, while raising all these questions that why these financial papers were not disclosed, the suit was filed in July 2023. 23, July 23. That time the financial papers, financial documents, audited financial documents were not ready. That's why we didn't disclose. We disclosed the previous year's financial papers. So, my lord, kindly, and we cannot disclose, my lord. It's a commercial suit, and that was not necessary also, because, my lord, insurance company in their letter for repudiation of our claim has never disputed that claim is fraudulent. They never allege any foul play. There is not, but they have never also made any such allegation. So these are all submissions from the bar. Not even there is a pleading on the part of the defendant alleging any sort of malpractice. Now, my lord, kindly once, since this question is irrelevant, absolutely impertinent, but since the question has been raised, my lord, I'll show only one document. page 184 of the judge's brief. That will be in volume 2.
Yes.
Well, 2.28 crores is for my business loan, for running my business. Well, this document is a loan sanctioned loan of rupees 5 crores sanctioned by Punjab National Bank, nature cash credit on lending to farmers fresh. Well, under the West Bengal Cold Storage Act, a cold storage owner, many a times as per government directives or many a times on their own, they advance loan to the farmers for cultivation purpose. And when the crop is put into their cold storage and thereafter, after the storage time, it is released, that loan amount is realized with bank rate of interest. So this advancing credit facilities to farmers through cold storage is a statutory scheme under the Cold Storage Act, West Bengal's Cold Storage Licensing and Regulation Act.
Yes.
So, my lord, all these issues regarding why there was 7 and what was the utilization of loan, I am not going into the question. Only one point I would like to make here, that since there was no allegation of foul play, there is no allegation of foul play on the part of the plaintiff in the letter of repudiation, insurance company cannot go beyond that. If they had hypothetically filed their written statement also, then also they were precluded from going beyond what is stated in the repudiation letter as per judgment of the Honorable Supreme Court.
Correct.
That is Calcutta Power and Telecommunications. Now, since that judgment is no more relevant in this case because there is no written statement, so we have not placed that judgment. Now, my lord,
That's why he has taken all the plea in the argument.
That's
Yes.
it. I have argued all these points before your lordships.
No, the other party,
Yes.
Mr. Sen is telling that they are not filed the written statement. That's why he has taken all the points on verbal.
Yes.
Yes.
Now, my lord, my learned senior has thoroughly explained what is the interpretation of the clause, which is a bone of contention in this matter. Whether contamination to be covered requires a precondition of rise in temperature for certain period. Now, my learned friend's submission, as so far I remember, was
Sorry to
that
disturb you, but during my this professional career on this, I didn't find any case where the insurance company has settled the issue, settled the claim.
And lawyers like us are put into difficult situation. They are defending the insurance company.
What has happened with me, personally, I tell, there was the insurance claim and no insurance policy. So the yearly or whatever the quarterly it was going on, at that time I was in profession. One time I find that there was a policy. It was over, matured. Then I contacted the insurance policy that they're telling that it has gone to the pension policy. Now I am 30 years old and it has gone. Then I requested to release, but they are not released. Then I have to file the commercial case, consumers court case.
But I used to, at one point of time, I used to give opinion and advice on big claims to National Insurance Company. So I have a lot of senior officials, my friends, my personal friends. We meet outside office, we discuss a lot of things, we chat. Now, in one matter, a matter has come to me for opinion. That was a matter of around 37-38 crores. It was a furnace, steel plant.
So the surveyor said ki it is not payable for this reason. So they took my opinion. And I said, I read the entire brief. I took some time. I read the entire papers. And I said, you cannot repudiate this claim. Now, if you repudiate this claim, you end up paying the double because of litigation will take some time and will pay up interest.
Correct.
So why don't you negotiate and settle? It was my advice, unofficial advice to the general manager. So the general manager said very candidly, because these are PSUs, he said, Mr. Sen, I am now 2 years from my retirement. If a surveyor said don't pay, if I pay, then
you will
day
be in
before my
trouble.
retirement, there will be a vigilance case.
Correct.
So you take it from court and take as much money as you want.
Even you see the arbitration award, Mr. Shah is opinion on many matters. If you get why the authorities are going to that's why nobody wanted to take the burden.
Yes,
That's right.
Comes a personal liability on the officer.
They don't want to take the
Yes,
burden.
yes.
Let the court decide. They are not thinking that okay, court will decide, but what would about the interest and the litigation cost?
My lord.
That is the problem.
And well, how much claims we have settled. It does not happen in reality.
Yes.
My lord, in National Insurance, there's a National Insurance Institute
Hmm.
in Pune. So once I was invited there. And to give a lecture on marine hull insurance. Now we were having dinner after the lecture. I'm not naming the insurance company, but the CEO of that company was sitting in the same table. And I happened to know him from before. So we are discussing that sometimes I find your policies are weird. I mean, there is no nexus between the object that
And
is
the
insured and the indemnity.
Yes.
So he said, in a very candid and a very light mood, Mr. Sen, you know, we have our marketing team and claim settlement team. We don't have any underwriting team who write the policy. We don't have any underwriting team. We have marketing and settlement team.
Correct. That is
So that's the reality, my lord, we have to face. So, my lord, can another date be fixed? Because I'll take some time and my learned senior will
No, I don't think we'll take much more time, my lord. I think another 15-20 minutes should be more than enough.
complete it. So next day
my lord, 10-15 minutes. My learned senior will make submissions and he will not take much more than 10 minutes. The other will not take more than. My lord, 15th is time is available. 15th is last matter, my lord. Your lordship's calendar, one time is available, my lord.
Counsel for the plaintiff has argued the matter in reply at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 15th at 3:45 p.m.
3:45. No, that was postponed.
Well, we'll try to come with a written notes of arguments and file it on the same.
Written notes and complete it so that.
Right.
Because it requires further consideration for me also.
Yes.
And my lord, in any case, my lord,
Why
if it is not
harping upon parted?
My lord,
so next day, that's I'm telling you, next day you complete CAB automatically parted.
We'll complete on the next day. My lord, in any case,
nothing will happen.
The matter is not taken up.
Vacation.
There is a
before 15th, nothing will happen. Don't worry.
That's
I will complete on the 15th.
Before that, nothing will happen.
I'm deeply obliged, my lord.
Grateful. Very grateful, my lord.
Yes. बताया अच्छे अमर